Yep, Senator, we are live and you're set to go.
Okay, welcome everybody. I'm Senator Kevin Avard from District 12, and today we'll be holding a meeting of the Senate Energy and Natural Resources Committee. Before we get started, I will read through a checklist to ensure that the meeting that we're holding is in compliance with the right to know law. As chair of the Senate Energy and Natural Resources Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12 pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I'm confirming that we provide public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform and public access to contemporaneously watch and listen to the meeting on Zoom or YouTube, and via by phone, following the directions and the link provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We're providing a mechanism for the public to alert the public body during the meeting if there's any problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us. That's remotesenate@leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting, it will be adjourned and rescheduled. Please note that all votes taken during this meeting shall be done by roll call vote. And finally, let's start the meeting by taking a roll call in attendance. When each member states their presence, please also state where they are and if anyone is in the room with you during this meeting, which is required under the right to know law. And I will start the roll with Senator Gaida.
Yeah, Senator Guide is at home in Warren, alone in my room, but occasional transits from grandson and daughter.
Senator Gray. Senator Gray, you're muted.
All right, we'll try this way. I am James Gray. I represent Senate District 6. I'm in my home in Rochester, and I'm alone in this room.
Senator Perkins Quokka.
Yes, sir. Senator Perkins Quokka. I'm at my home in Portsmouth, and I am alone in this room. My family is downstairs.
Senator Waters will be away for a while. He may join us a little later, so we'll when he gets in, he'll introduce himself. I'm Senator Kevin Avard, District 12. I'm in my office at home. I have a puppy in the house who may be loud, and we have a couple of other people, but they're not in the room with me. And with that, I want to welcome everybody. How's everybody doing?
Great, thank you.
Good. All right, so I guess our first bill is going to be Senate Bill 129. So we'll open up the hearing for Senate Bill 129. And our prime sponsor, I believe, is Senator Jeb Bradley.
Yes, sir.
Senator Bradley, you were recognized. How are you today?
Good morning, Mr. Chairman and members of the committee. For the record, Jeb Bradley in Wolfboro. I'm pleased to be here as the prime sponsor of Senate Bill 129. This bill came as a result of a process that's occurred over the last year or so that came out, I'm told, of a court case that has slowed construction throughout the state of New Hampshire due to a new review process of alteration of terrain permits. The permitting process has been slowed, and as a result, this bill is necessary to make sure that that process continues, that there is not a significant jeopardizing of conservation species, that the language on lines 9 and 12 indicating that any action is designed to avoid and minimize harm. And then lastly, a new section of law, the Fish and Game Fund, it allows a mitigation fund for unavoidable impacts. So I think, Mr. Chairman, you're going to hear from a number of people today that are very concerned because construction is such a large part of the economy, that the slowing of these alteration of terrain permits is problematic for the construction industry. I would say, from what people have told me, this is not the only way to resolve this. It's likely that Fish and Game is going to need more staff to review the applications. I'm told there's only one person right now who is reviewing these permits at Fish and Game. That's something we may have to deal with in the budget process. And also, I think it's going to be important if we pass this legislation that Fish and Game probably further clarify in their rulemaking process what significantly means. So I'm going to stop there. I know that there are a lot of people that want to testify. I would just say a lot of jobs are on the line, and I hope we can move forward with this bill.
Oh, you're muted.
Senator Quokka, you were right.
Yeah,
I
thank you.
apologize.
Thank you, Chair, and thank you, Senator Bradley. Appreciate the intent of this bill. I was just wondering on Section 2, if any discussion had been had about setting an amount, perhaps per acre, for the fee in lieu.
Not to the best of my knowledge. That would be a discussion, for anybody here representing the Fish and Game Department or others that may be involved.
Okay, thank you.
Committee members? Senator Bradley, you had mentioned something about rules, the definition of what?
Of what significantly jeopardizing on page 7. A couple of people that I think are going to testify today have suggested that that would be helpful. So I'm just raising that as an issue.
I see. Seeing no further questions from the committee, we thank you very much. Oh, sorry, I apologize. We have Senator Gaida. I apologize. I didn't see the little yellow hand up there. We're gonna get better at this.
Beware the yellow hand. Senator Bradley, thank you for presenting this bill. My question, I think you've addressed it in part, is centered around that word significantly. Is there would GELCAR define that? Would the agency define that? Would the legislature define that? Because obviously the court, in seeing the word jeopardize, went all the way 100% to shall not in any way cause any possible harm, which is obviously the restriction that we're trying to remove. But significantly, is there a better way to express that, or is there a group that would organize to perhaps define that word?
That is a question I think that other people could better answer than I. I just raised it as a point that was raised to me, that the comfort level of what we're trying to do, which is make sure that these permits can go forward, and that significantly, like words like reasonable,
Right.
Which we use a lot in statute, sometimes need further clarification.
Okay, thank you.
Thank you, Senator Bradley. Seeing no further
Thank you.
questions. And next we have,
Mr. Ari Pollock.
welcome, Ari. And you can, yeah, you are.
Good morning. Hopefully you can hear me.
We can.
Super. Good morning, Mr. Chairman, members of the committee. My name's Ari Pollock. I'm an attorney practicing with the firm of Gallagher, Callahan, and Gartrell. I'm appearing before you this morning as a registered lobbyist for the New Hampshire Home Builders Association. The Home Builders Association supports Senate Bill 129, because the bill addresses a critical permitting bottleneck that is threatening land development and economic growth across New Hampshire. As a 20-plus year New Hampshire land use attorney and a longtime lobbyist for the home builders, I understand and I appreciate the need for balance in matters of environmental policy. Frankly, when matters swing too far toward protection, projects that are critical to housing, jobs, and the economy suffer. And when matters swing too far away from protection, our natural environment suffers, and neither extreme is desirable. Senate Bill 129 addresses a real and an urgent situation where at least we believe the pendulum has swung too far toward one of those extremes. And by way of brief background, most significant development projects in New Hampshire require a permit that's known as the AOT, or the Alteration of Terrain Permit. It's issued under the jurisdiction of New Hampshire Department of Environmental Services, and the state regulates through this permit changes to land grade, drainage, runoff, and generally speaking, surface coverage of property and stormwater management. You don't want your construction, for example, to cause a flood on the next person's property. The New Hampshire Endangered Species Act, which is codified as Chapter 212A, is a broadly worded conservation-oriented statute that requires consideration of wildlife impacts whenever the state acts or permits an activity. The ESA is, in essence, requiring DES and other agencies like DES to think about conservation when permits like the AOT are applied for and issued. Wildlife impacts are one of many factors that are considered in deciding whether or not to grant permits. Wildlife considerations, for example, are similar to consideration given for impacts upon abutting properties, abutting uses, preservation of historic structures, archaeological and artifact screening and protection, and other design elements. In short, all of these factors are in the mix and they are balanced against one another and the needs of the applicant. A recent 2019 Supreme Court case, however, upset this prior balance. The court held that the language in the New Hampshire Endangered Species Act prohibited DES from issuing alteration of terrain permits that jeopardized threatened and endangered species or their critical habitat areas. The interpreted language came right out of the statute, and the court essentially found no wiggle room and no flexibility. In other words, no space for the balance that we had become used to and we rely on importantly. In response, the department quickly adopted a new administrative rule that added a specific wildlife screening to their current process. It required a more robust wildlife review. The rule, however, does not and of course cannot alter the statutory mandate. Additionally, the rule lacks detail in terms of the process and procedure for these reviews, and consequently a bottleneck is occurring. Both DES and Fish and Game are brainstorming to pursue additional rulemaking. And that rulemaking will almost certainly need to address the parameters of wildlife study, the qualifications of wildlife experts, the role of Fish and Game in peer review for a DES permit, the role of abutters in the permit process and appeals, the relative authority of DES on the one hand, Fish and Game on the other, and of course, who bears the responsibility and administrative expense of conducting these additional and more robust reviews. These are serious problems that need serious deliberation, but as you all know, the administrative rulemaking process is procedural, slow-moving, and frankly, COVID impaired. Stakeholder meetings by Zoom, no ability to assemble and brainstorm. It hampers that process, which on its best day can be inefficient. Meanwhile, New Hampshire's economy is suffering and the fallout on development industry is mounting daily. There's a growing backlog of applications at DES and Fish and Game, and phones are ringing at the governor's office, the executive council, commissioner's office, and probably many of your legislative offices. Whereas the AOT, or Alteration of Terrain program, used to have a predictable review clock, a manageable permitting track of 50 days from beginning to end, the current wildlife curveball has caused a deviation from this predictability and applications are languishing for unknown periods of time. DES needs the statutory ability to triage applications and approve what is minimally invasive on wildlife considerations. They need legislative support so they can get back on solid ground when the next court case is filed. There will be a next court case. Senate Bill 129 essentially hits the reset button. It restates the policy and hopefully gets the court to reinterpret legislative intent, an intention to move to a more modified, a more balanced, a more results-oriented landscape where these important projects can move forward. The language of Senate Bill 129 is intentionally simple. It's simple because we really don't have time for study committees or interim study, re-referral, the things that are typically done to flush out details. The term significant is inherently subjective, but as you all know, legislating matters of degree is a delicate business. Subjective or not, I think most would agree that adding the word significantly before jeopardize modifies the existing phrase, do not jeopardize at all. It creates a more flexible standard of review. And frankly, the question of how much more is a good question, but maybe just enough to keep important projects moving forward until rulemaking and other processes can fill in that blank, can work on definitions, and can provide those details. And so the bottom line of the bill is with flexibility comes balance. We absolutely need rulemaking. The details are important, and the administrative process, however, must fit within that law. I think Senate Bill 129 brings our balance back, and the Home Builders Association asks that you vote ought to pass on the bill. Thanks for hearing my testimony, and I'd be happy to take any questions from the committee.
Senator Guddy, you're recognized.
Thank you, Mr. Chairman. Mr. Pollock, is it my understanding that all agencies within state government are saddled, for lack of a better word, are encompassed by this statute or this proposed legislation?
That's correct. The section of the Endangered Species Act requires that agencies that are either conducting or permitting activities be mindful of the impact of those activities or permits on threatened and endangered species and their critical habitat areas. And that's a good thing. And we want that policy, but we can't have that policy shut the door completely.
Follow up?
Follow up.
So then, does that mean that these individual agencies are each going to look at the impact of their respective projects? Or is there one central repository, for example, DES or DNCR, under which all of these inquiries about impact would take place?
That's really an insightful question, because what's happened to this point is each agency conducting the activity or issuing the permit has tried to build a wildlife review into their program. And so, for example, what's happened now is DES has a rule within its AOT program to address, at least on a skeletal level, how this should occur. The details in the bones on the bones need to be flushed out. It may very well be that the solution is to have Fish and Game adopt rules of its own for how it is going to conduct these matters. But yes, it needs to appear in one place or the other.
Follow up?
Follow up.
Would it make sense to have one agency designated as, if you will, for standardization purposes in terms of defining significantly or any other metric? Have one agency designated as the agency that would investigate all of these department potential encroachments on the wildlife?
It may, Senator. I think there's any number of ways to deal with the administrative rulemaking piece of the puzzle, but on the policy level, on the statutory framework level, I think more flexibility needs to be built into the statute so that those rules can be recognized as lawful and not ultra vires or outside the scope of agency authorization.
Thank you very much. Thank you, Mr. Chairman.
More questions? So, Mr. Pollock, thank you for your testimony. I'm just curious, just for the general public, when they're looking at this, when you say agencies, what could you give an example by name? What type of agencies are affected by this?
It is primarily DES. Their AOT program their wetlands permitting program, all of their land bureau or land and water bureau programs. But certainly DOT is impacted by these reviews, and I believe you'll hear from them today. It's any agency like a member of the public who is pursuing a project and requires these permits.
Okay, any further questions? Thank you very much for your testimony. We really appreciate it.
My pleasure. Thank you.
And we're going to recognize Senator Waters here as far as welcome to the committee. And is there anybody in the room with you?
Thank you, Mr. Chairman. I am here alone in this room in Dover. Thank you.
You're welcome. Senator Quokka, did you have a comment?
No, I was just saying hi to Senator Waters.
Oh, okay. All right. So
Okay.
next on the list, welcome. So who's next?
We have Chris Norwood from the New Hampshire Association of Realtors.
Good morning, everyone. Can everyone hear me?
Yes.
Great. My girls tend to play with my laptop and then it doesn't work. My name is Chris Norwood. I am the president of NAI Norwood Group, a commercial real estate brokerage firm. And I'm here on behalf of the 7,000 members of the New Hampshire Association of Realtors in support of this bill. So thank you, Mr. Chair and members of the committee for listening. I'm not going to speak to the technical points. I think there are other folks in the virtual room here that could do that. What I just really want to emphasize is that alterations of terrains permits are much more common than we think. So I believe the threshold is 100,000 square feet of impacted land will trigger an AOT. It's 2.5 acres or so. And while we think of 100,000 square foot building, my God, that's monstrous. But the reality is if you're developing an industrial building or a single family subdivision or a condominium, you can get there pretty quickly because you have to add in all of the parking lots, the retaining walls, retention ponds, any sort of slope and drainage. You can get to 100,000 square feet fairly quickly. So when you're talking about timelines for permitting, you already have the municipal permitting whenever you're talking about a development project. That could be 4 to 6 months or longer. As was mentioned earlier, AOTs in the past take about 2 months, a little bit more to prepare all the work. But now what we've had since this new court ruling is another roughly 2 months of bottleneck. And it's not laying fault. I think it's just a matter of the circumstances. But we're approaching, a year plus, maybe a little bit shy of that, as a fairly common occurrence for what I would consider reasonably scoped projects. So I think, as was said prior testimony, we're looking for balance. We do think that this bill is reasonable in that regard. And we do appreciate your consideration, and I am happy to answer any questions. Thank you.
Questions from the committee? Not all at once now. Thank you very much. We appreciate it.
Thank you, Mr. Chair.
Okay, and next, Mr. Chair, we have Jim O'Brien on my list. Let me just bring him in.
Welcome, Mr. O'Brien.
You can.
Good morning, Mr. Chairman and members of the committee. My name is Jim O'Brien. I am the Director of External Affairs for the Nature Conservancy here in New Hampshire. And so I am going to be testifying on behalf of the Nature Conservancy, but also on behalf of 4 other conservation organizations, the New Hampshire Rivers Council, New Hampshire Audubon, the Appalachian Mountain Club, and the Society for the Protection of New Hampshire Forests. And we've sent a letter of our testimony, but I'll sort of highlight a few points. So we're here to offer our qualified support of Senate Bill 129. We support the concept of the bill, but we believe there's some changes that are needed to ensure that the intent of the legislation is met. The first item I'd like to speak to is, it's been a topic already of a few comments, is the addition of the word significantly on page 1, line 7. I think it's important to look not just at the word right after significantly, which is jeopardized, but to look at the whole clause, which is jeopardize the continued existence of a species. And so that's a pretty high bar, jeopardizing the continued existence of a species. And when you put the word significantly, I think, in front of it, I think it adds a level of confusion that I think we're trying to avoid litigation. But when I see that word in front of it, it is so subjective that I could see this creating more confusion moving down the path. Our advice is to define through rules, what does jeopardizing the continued existence of a species mean, rather than trying to qualify it with significant in front of it. I was trying to think of a sort of a corollary to this. So how does one significantly jeopardize the continued existence? This might not be the right way to say it, but I was thinking of, something is either dead or it's not dead. It's really hard to be significantly dead. And so in this case, either a species is being jeopardized, its continued existence or not. Adding the word significant in front of there seems to just confuse the intent of the bill. The second addition that we would ask is sort of on the rulemaking process. Currently, RSA 212A doesn't have any rules associated with it. The department does work with developers and work with the Department of Environmental Services on doing environmental review, but there's additional terms that are not defined. And so one term is critical habitat. There is no definition of critical habitat. And we feel, as conservation organizations, as I'm sure developers feel, that having consistency in review and having a consistent understanding of how department is making their decisions and making their recommendations that is transparent and publicly available is very important. And so while the Department of Fish and Game has the statutory authority to do a rulemaking process, they have for years, there continues to not be any rules on this provision of law. And so we would like to see the legislature require, through an amendment to this bill, required a Fish and Game to do a rulemaking process, and so that these terms can be defined and we can all have an understanding of how they're making decisions moving forward. And that's especially important if there's going to be allowance for mitigation, again, which this bill does. And our organizations aren't opposed to that concept, but again, we're looking for transparency and an understanding of how decisions are going to be made, leading a developer to be able to mitigate their impacts to either critical habitat or to threatened endangered species. And that's important in Section 1 of this bill for rulemaking, and we would argue that it's even more important in Section 2 of the bill. Section 2 of the bill, sets up the ability for Fish and Game to receive mitigation payments. And again, we're not saying that's a bad thing, but we would like to see rules around how those payments are received and how those payments are put to use. So what kind of projects are they going to be used for? If there's an impact to a specific species for development, we would like to see the mitigation go to the conservation of that species. And so there are other examples in state government where we have mitigation accounts. A good example is the ARM program for wetland impacts at DES. There's clearly defined rules for how decisions are made to both receive and then spend those dollars. So we feel that a similar provision can be made here with Fish and Game. And currently the bill just has the mitigation payments going directly into the non-game program account. Again, we would just like to see more segregation of funds rather than going into the full program, that it goes into an established mitigation account that then has rules associated with how those funds are expended. So again, we've sent a letter which sort of gets into a little bit more detail on these items. So with that, I'm happy to answer any questions. Thanks for your time.
Senator Cuoco.
Yeah, thank you, Chair, and thank you, Jim, for testifying. So what you're saying is New Hampshire doesn't have, similar to other states, like a website where you can kind of go on and turn on the layer for habitats. There's no sort of uniform system where you can do that diligence or research on a high level. You have to actually be in conversation with the agency on a specific project.
Thank you, Senator. So we do have those layers. So there are habitat layers. The difference is there's not, I guess in the decision making, it's unclear, at least, so Fish and Game has a process that they use here, but I think it's unclear to, to me as an outside observer, exactly how those layers are considered. And so there's no rules, again, there's no rules defining how Fish and Game looks at projects, looks at critical habitat and makes these determinations. And so, I have trust in Fish and Game's decision making. But I do think for clarity for both developers, conservation organizations, and the public, really knowing what is considered critical habitat, how they're defining that in terms of their environmental review, I think would help everybody understand, how decisions are being made on development projects. And then if they're going to be doing mitigation, what kind of critical habitats are then being disturbed and the mitigation would be used in order to rectify. So I think the information is available. It just hasn't been put into a publicly transparent set of rules, so everybody's on the same playing field when we approach these issues.
Sure. Follow-up. Yeah, thank you, Jim. That's helpful. I guess I'm still hearing in your answer something that is important to me, which so we have those habitat layers that are available for someone to do diligence on with a project, but it's unclear which parts are designated critical, or it's just unclear if you were planning a project and there was critical habitat present in your proposed development, what the consequence of that is.
I think, thank you, Senator. I think I think the answer to your question is yes. Those are all unclear at this point.
Okay. And just one last question. Yeah, thank you, Chair. I did like your comments on sort of clarifying what the fund would be used for. I know a fee in lieu is not an uncommon project, but or an uncommon structure. I think sometimes there's land conserved in lieu or a fee in lieu. There can be alternatives. So was there conversation about how to structure that in this case that you were involved in, Jim?
Thanks for the follow-up. Yeah, so we've done some research and looked across the country at other programs that states have for, specifically for threatened and endangered species, because it's not as simple as mitigating for wetland impacts. It's a bit more complicated because because there's all sorts of different habitats that may be impacted, and there's not a lot of threatened and endangered species, but there's a number of them. And so how do you a lot of in lieu programs like the ARM program, has a pretty set formula for how much disturbance you have, and then a payment that would result from that. I think it's a little more tricky with threatened and endangered species and habitats. And so, so we do have some examples of what other states have done in this regard, and we could bring that forward for consideration if that's a change that the legislature wishes to make.
Yeah, no, I'm not necessarily proposing changes, just curious about the context. Thank you, Chair. Thank you, Jim.
Senator Waters.
Thank you, Mr. Chairman. Thank you, Jim, for your testimony. I've got a number of questions, if I may, Mr. Chairman, and I think I'd like to start on the rules side of things. That would it be fair to say that if there were a rulemaking process here, that really the rest of the bill might be unnecessary?
Thank you, Senator. It's a great question. I think the rules will help a lot, because I think the rules will help define. In the policy question, I do think having the words, and I don't have the bill in front of me, but putting the mitigation hierarchy, the avoid and minimize, into statute helps, because I think part of the challenge and part of the problem is that the current law may not. There could be questions about whether the current statute allows for mitigation in terms of the impacts of species. So I do think having that language in there is helpful. And then but I do think having Fish and Game undertake the rulemaking process is going to help define the terms that are currently in statute a lot better than they are now.
And if I may follow up, wouldn't the rules process also allow the kind of consideration in a more deliberate manner as to how we think about habitats and what we define as critical. I just would comment too that what you're suggesting about the direction of funds seems to be the way that Federal Highway does things, and I think it just would make a lot of sense, because the point is isn't the point for the whole, for a critical species and habitats that that because they cross borders and they go boundaries and beyond one project, that you're looking at the overall ecosystem that habitat or for a particular species, so that mitigation funding probably ought to be directed to that purpose. Does that make sense?
Yeah, that makes sense. It's, we're really trying to, if there's going to be impacts to a habitat or a species, what I think the best approach is to mitigate or to conserve habitat as close to the impact as you can. And in the case, again, of threatened endangered species is challenging because there might not be, they're threatened for a reason. They're threatened and endangered because of loss of habitat. And so at times it's hard to, mitigate like habitat as close to the project as you might want. So there's a long-winded answer, but I think your premise is correct, Senator.
And if I may, Mr. Chairman, so to the issue of determining habitat as critical and actions designed and significantly, and and why rulemaking may be really a way to go on this. I mean, isn't it the case, and I maybe just preface this with a couple of examples. In the work that we've done on wildlife corridors, and we call them habitat strongholds, but it became very clear that the way of thinking of a landscape and of survivability of species and habitats, it just can't be piecemeal, because you have ecosystems and connections. And so that it becomes really important that you don't lose viability by an accretion of changes to that habitat. And I'll just mention something that's quite visible in the seacoast area of the state, that the piecemeal development process over many decades has led to the deterioration of the Great Bay. And now we're spending, we've already spent hundreds of millions of dollars, and how many more hundreds of millions of dollars are going to have to be in the pipeline, because what are we looking at? We're looking at things like the loss of shellfish, which were natural filters, and the expense that's going to restore those habitats, and then we're looking at eelgrass, right? Eelgrass restoration, and that being a kind of a barometer species whose absence is driven, again, those hundreds of millions of dollars of wastewater treatment upgrades and MS4, and we've got a new EPA mandate now upon the area as well. So in that regard, then doesn't it make sense that doesn't it appear that this language perhaps doesn't adequately address what it is to avoid or minimize harm, or what it is that something's critical, or what significantly means, because that's much more complicated than a development on a few acres of land. Isn't that the case?
Yeah, there's a lot in that question, Senator. I appreciate it.
Really.
No, and this is, this is a challenging issue. And I think, at least from conservation standpoint, I think from Fish and Game, what I think a lot of our efforts are designed to do is to keep species from becoming threatened and endangered. So you spoke of, habitat strongholds. Our goals are aligned to make it so we don't have, threatened endangered species, which then complicate, I think, a lot more. So the more that we can think about this in a more holistic manner, I think the less we'll struggle with these issues. But I think to your main point, and I keep going back to the rulemaking, which we just feel is a very important component to this, because sometimes these issues are hard to define. And so the more clarity we can get on how our departments are making their regulatory decisions, I think the better. And in this case, these issues like critical habitat, are not quite defined. And so I think the more that we can, as a state, narrow in on what we mean, I think the permitting decisions in the litigation that sometimes results will be much clearer.
Just a last follow-up to kind of bottom line after we get out of the weeds of the eelgrass on this, that the point it seems that you're making is that, and I'll speak to someone who's been one of the strongest supporters of economic development in my region. That your opening with your testimony is that qualified support, and that we recognize that time is money for developers, and that there are ways to work around this. But the advice isn't your advice to say, look, let's get this right?
Yeah, thank you for that question, Senator. Yeah, so we're not opposed to economic development. Actually, we want to, we support it. Our case is that, I think we'd be better off if we can more clearly define what we mean by critical habitat, jeopardizing the continuing existence of species, because I think that will make all of our work easier. And will make permitting a lot easier and probably go faster if we can define these terms and be comfortable with those definitions.
And thank you. And thank you, Mr. Chairman, for your indulgence.
You're very welcome, sir. Any other questions? All right, I do actually. If I don't know if Jim, if you heard the previous testimony, but there were a couple of key words: balance, triage, and bottleneck, and COVID impaired. I'm not sure. Are you familiar with the process of with rulemaking and how long it takes?
Thank you, Senator. Yes, I've been involved in many rulemaking procedure. I appreciate sometimes they're long and arduous.
They're long and arduous. So, if we depended specifically on rulemaking, that could still continue to the choke off permitting or the balance, if you will.
Sure. So I can speak to that. So there is a balance, and we appreciate and support. So threatened and endangered species are not common species, and so we're not talking about every application for an alteration of terrain permit. I think when DES have been working through their rules, and I might get this number wrong, and they could probably correct me, but I want to say they had they mentioned like 40 applicants, maybe a little less than 40 applicants that touched on threatened endangered species, and not all of them are complicated or complex. And so again, these aren't all species. These species aren't everywhere, and that's why they're threatened and endangered, and that's why we have habitat labeled as critical. So there is a balance needed. We appreciate that, and we feel that, again, defining these terms. And I know our agencies do great work, and they're working on this as we speak. But again, we're looking at the long term here, and really want to get this right. And so that's why we feel a rulemaking process that the legislature would ask the department to undertake. Those rulemakings do take time, but that doesn't mean that development stops as rulemaking proceeds. Mm-hmm. The rulemaking process can move forward as well as permits being issued at the same time. So it doesn't stop permitting to do a rulemaking process.
Right. So overall, in the theme of balance, this bill helps at the same time while we look into rulemaking as well. Correct? Correct.
Yeah, and we feel, again, the mitigation language here. We feel it's good to have. It's important, and the Fish and Game has done mitigation for impacts, and so they do know how to do this. And our ask is that they can continue to do that and start to put rules in place so that the public understands, what they're classifying and how these decisions are being made.
One thing I do like about these Zoom hearings is the fact that the public has more access to these hearings. But one of the downfalls for the public is that when somebody shouts out, well, AOT, unless they define it, they really don't know what it means. So I've been one of those in the past, and I usually ask people, we talk about ARM. What is ARM, just for the public to understand? What is ARM?
Yeah, thank you, Senator. So ARM stands for Aquatic Resource Mitigation. And so it is a program, if there's going to be wetland impacts from a development, the agencies want you to avoid those impacts first. And so, design your development so that you're avoiding, if you can't avoid, then to minimize your impacts as best you can. And then in the case where the development can't either avoid or minimize, there's still going to be impacts to the resource. Then the state has set up a program called the ARM program, Aquatic Resource Mitigation, by which a developer will put dollars into it to mitigate their impacts. That money goes to a segregated account within the Department of Environmental Services. There's a committee that helps make resource decisions that then does wetland restoration or wetland conservation in order to mitigate the impacts that was done to the development. Hope that helps.
It really does. It just seems like we're used to this. We're used to these languages, and I just like the fact that people can be, as they're learning how we're doing it. There are a ton of little AOAs and ERFs and DES, and people have no idea what we're talking about.
A lot of acronyms out there.
Yeah. Thank you very much for your testimony. I just need to ask Trish, how are we doing on time?
We are doing well. We have 4 more speakers.
4 more speakers. Okay. And any other questions before we lose Mr. O'Brien? Seeing none, thank you very much for your testimony. We really appreciate it.
Thank you, Senators.
Okay, our next speaker is James Gove. Mr. Gove, you can unmute.
Okay, can you hear me?
Yes.
Yes.
Great. So I'm testifying for myself, and we being my company is environmental services company. We work with developers, and we do these studies. And I thought I'd put this in context. You've heard a great deal of information now. I've put in written testimony. I don't want to reiterate that. What I would like to do is kind of give you kind of boots on the ground analysis of what's going on. To date, my biologist has done 60 wildlife habitat assessments for the purposes of alteration of terrain. We know we give these to the engineers, and they bundle them up in their package to go to alteration of terrain and to Fish and Game. We think about 30 of them have been submitted. And the process is that Fish and Game then looks at that after AOT has done their review. They then send it to Fish and Game and say, please give a draft review. Fish and Game does a draft review, and then it goes back to the engineers for any modifications of the plan in order to protect potential threatened or endangered species. Then we do a final review, and that's when alteration of terrain issues their permit. To date, we know 6 have been issued. So we've done 60, 30 have been submitted, and right now 6 have been issued. And I want to make it clear that prior to this new process, we were still doing protections for threatened endangered species. And frankly, the same protections we were doing prior to this are the same ones that are being implemented now. So we aren't seeing any empirical evidence that this greater review is leading to greater protections. On our projects, we are doing the same things that we did before as we're doing now. We're putting buffers onto vernal pools. We're making sure that the proper erosion control measures are being implemented so we don't capture hard-nosed snakes. We make sure the sumps are taken out so Blanding's turtles don't fall into them. We're putting in the critter crossings that we did before. So I guess what I'm trying to tell you is we have seen not once the reviews are done, we haven't seen like massive changes in projects. All right. It seems that the same things we were doing before with avoidance and minimization, we're doing now. And so honestly, I don't think we're going to have any reduction in the same conservation measures by this adding these words to this bill to make it allow for avoidance and minimization. I don't think we're going to have any reduction in the protections to threatened endangered species beyond what we have been nominally doing every day anyway. So I'll be glad to answer any questions.
Senator Waters.
Thank you, Mr. Chairman, and thanks for your testimony. And I hope business is going well. And we've got kind of a economic boom going on, oddly, in construction, and
Yes.
it's good to see. So my question is that, would it be fair to say that the issue is less the legislative language here than it is the capacities of Fish and Game to handle as many requests as come in just because of their staffing?
To be honest, I believe it is absolutely the inability of Fish and Game to handle the requests. If we think in terms of alteration of terrain, and we have to do these studies for every single alteration of terrain, it is not a case where if in fact we have New Hampshire Heritage Inventory takes a look at it and say, oh, you have a threatened endangered species. No, we have to do it for every single alteration of terrain. So you think about that, we have 200 alterations of terrain that come into the state. One person at Fish and Game is now tasked with handling those 200. And if we look at the process where we have a draft review and then a final review, that person is actually handling that project, handling those projects 400 times. That's a lot. So I do think there is a real inability of Fish and Game to be able to process these things.
Well, thank you. Just to follow up, Mr. Chairman. So, I mean, your story is one that we hear frequently in people trying to deal with many state agencies, that we've got great people working, but it seems to me what you're saying is that we really aren't providing enough support for our agencies and enough staff so that you all can get your business done in a timely way.
Correct. That's absolutely right. And to be totally honest, my clients are not objecting to these additional studies. I mean, I'll tell you right now that the studies that we do, depending upon the size of the parcel, range between $2,000 to $4,000. And so what we're finding is the clients, because alteration of terrain has to do with fairly larger projects, right? 2.5 acres or more in size. It can be residential, it can be commercial, it can be industrial. And what we find is that they don't object to paying the fee to do the assessment. What their objection to is, where is it once I file it? Why can't I still get an alteration of terrain permit in 50 days? Why is it taking 6 months?
If I just one more follow up on that, then, I mean, we have in the Department of Transportation area with driveway and road permits, we did pass some legislation a couple of years ago, which set a pretty hard timeline that by which the agency had to get this done. And so would that help you all out if we had a pretty hard timeline after 30 or 60 days that this had to be done?
I think it would help if that timeline is applied or is written into rules of the Fish and Game. And the reason I say that is because I see alteration of terrain meeting their timelines as far as review of the engineering aspects and the erosion control aspects and the stormwater aspects of a project. And so they already have a timeline, and we get requests for more information to basically extend that timeline because they have not gotten anything back yet from Fish and Game. So the issue is that if there is a timeline put in, I think it has to be with the Fish and Game Department.
Any further questions?
Thank you, and thank you, Mr. Chairman.
Thank you. I have a question. In our first testimony, they talked about a 50-day, but because of the, he called it the COVID effect, if you will. The 50 days has been extended, and were you listening at that point? At that time,
I was.
So there is an understanding of a timeline, correct?
Correct.
Can you tell me, are you in support of this bill?
Yes.
Okay, and I guess that's what I wanted to be clear on. So the reason you're in favor of this bill is because it does what?
Well, the reason I'm in favor of it is because it basically brings us back to the same standard that we've used for the last 20 years before we had the Supreme Court decision. And so before this, we were always required to avoid and minimize impacts, whether it's to wetlands or to threatened endangered species.
Mm-hmm.
And so suddenly we have a new standard that says no impact. And that's a very high standard to meet. And so I'm in favor of this because I believe that this language will lead to several things. It will lead to essentially the same kind of standard we've used in the past, which has worked, by the way. We have conserved threatened endangered species using that standard in the past of avoiding minimizing. Also, it does something else. It actually creates a fund where if we can't avoid it totally, avoid some impacts totally, it allows for the funds to be utilized to help protect other habitat areas. And I think that's important. That's something we've actually been missing for the most part in dealing with these threatened endangered species.
I wrote down, I like to call it the Department of Bureaucracy, but when you were talking about a review, then there's a draft review, and then there's a what? Are there two other steps?
Well, yes. So we have the alteration of terrain application goes in,
right?
And it includes with it the wildlife habitat study. It actually is submitted in dual process. It's submitted also to Fish and Game Department as well as alteration of terrain. Alteration of terrain then reviews it for all of the necessary elements of stormwater management, so water quality protection, all that stuff. And they typically have requests to the engineering staff to make some changes. When those changes are done and to AOT's satisfaction, it is then what they call a hot list or an active list. They send that hot list over to Fish and Game and say, look, we need to have you look at this application and tell us whether or not they've done enough measures or protected threatened endangered species and habitat. There's a draft review comes out. That draft view then goes back to alteration of terrain. It's sent to the engineers, and there may be some modifications. Maybe there'll be a bigger buffer to a vernal pool. Maybe there'll be a more another critter crossing put in, something like that. In rare cases, we've actually had units lost. Okay, so in other words, in a residential development, you actually lose a couple houses. Then that is sent back to alteration terrain and Fish and Game, and then Fish and Game has a second review to look and see if those measures have been put into place, and then they issue their final okay to alteration terrain, and then alteration terrain can issue their application.
And how long is this process?
Right now, engineers are telling their clients figure 6 months to 6 to 9 months.
And is that normal?
No.
What
No,
is-
not
what is-
normally.
What is normal?
Normally alteration of terrain has turned around their application review in 50 days.
So, okay, that's a significant change.
Significant.
Any other questions? Mr. Gove, thank you very much for your testimony.
Thank you very much for listening.
Okay, Mr. Chair, we have 4 more speakers signed up. Gary Abbott is next. Would you like me to time the testimony now or wait?
Yeah, we'll time it down to like 4 minutes at the most.
Okay.
Yeah. Mr. Abbott, you're on.
Okay, let me pull Mr. Abbott in.
Thank you very much, Chairman Avard and Senators. For the record, my name's Gary Abbott. I'm the Executive Vice President of the Associated General Contractors of New Hampshire. We're here today in support of Senate Bill 129. I'm going to be brief. I know hearing has gone a long time and you've had a lot of great testimony, but I want to make a couple of things really clear. In 2019, the alteration of terrain permits were pretty much done within 50 days, except those that if you look at the bill, line 5, this statute is about endangered and threatened species. So it's clearly defined what triggers this section of Fish and Game. You get over 200, I think last year there was over 220 AOT permits. And a small percentage of them were triggered by this statute to go to Fish and Game. So the majority of permits never left DES for this review. And there was a discussion earlier by a senator that there is a process. There was a National Heritage Bureau review, which listed where these endangered and threatened species were. That's how an applicant was triggered to go to Fish and Game. If they had one of these species, whether it was a plant or wildlife, it would go to Fish and Game. That process had worked for some 20 years. This statute was 1979. So the court looked at this different than we had applied this statute for all of those years. And it's clear they interpreted the words much stricter than it had in the past, where do not jeopardize was a major component of that lawsuit. So that's why the word significantly opens the door to go back to what we were doing in 2019 before the lawsuit. Now, what DES did is they processed some rules very quickly, and they triggered that all permits, all 200 plus, go to Fish and Game versus the few that were triggered by the National Heritage Bureau report. So suddenly you've got a department that's getting all of these permits that did not get them in the past. There needs to be a screening process. But one of the major pieces here is that none of this was well prepared in the sense that applicants agreed in the rulemaking process to have a wildlife biologist review of a project to help Fish and Game do a quick scan. They didn't have to go out in the field and check all the maps and do all of that stuff. So the applicants have encumbered a cost of doing this review with a wildlife biologist. Now, this rule went into effect in June. And I looked at some rough numbers of since June, some 99 permits when I last checked it have been filed since June. And only about 25 to 30 have been accepted. So I foresee the tidal wave. I can tell you our group is getting a lot of feedback because I represent contractors, developers who hire the consultants, and they're giving me the feedback. The tidal wave is coming of a real problem. We don't have a year of rulemaking to wait.
Right.
That is probably the biggest challenge. And also, nobody has really, I know there's been some discussion on the word significantly, but I think it opens the door for the next section that's bold, that you can avoid and minimize. I know there were 2 public hearings since those rules went into place, and those issues were brought up in those hearings that the DES held. I agree that I know 2 things we're dealing with rulemaking. Rulemaking has to follow what's allowed in the statute. You need to pass this bill so the rulemaking will follow the intent of the law.
Right.
So you need this additional language for the Fish and Game to develop those rules. Without it,
They won't be able to.
they'll be guessing at what is the intent, what is allowed, is avoid and minimize still in place. So I just wanted to, I know I'm on the clock for the 4 minutes, but I really want to emphasize that we have, the AOT process was one of our best in run permits that we've ever had over the years. No complaints, not like some other permit areas that we've come to the legislature with. This was really a strong thing that the Department of DES did. And I believed the National Heritage Bureau maps were very helpful in moving those endangered and threatened species to the department. So I don't think what's happened since the court case, 2020 has been really a train wreck from our perspective of that permit process. You have to do this first step to move to the second step. And so we're in strong support. It's one of our top issues for the session is that this needs to take place. The defining of these terms, yes, we understand there's going to be give and take through the rulemaking process, but you've got to have this in place. With that, I would answer any questions, and thank you, senators, for taking the time.
Senator Waters.
Yeah, thank you, Mr. Chairman, and thank you, Gary. I mean, I really hear what you're saying. What's hard for me to figure out is how much of this is the change in procedure and how much is the effect of COVID, where, I mean, as you know, some of these agencies saw for, and so still seeing for months that they've been pulled into the call centers and everything else. Now, I think there's a good chance by June we're going to be kind of much more back to normal and how people are able to do their jobs. But I guess I really am asking if you really can differentiate the delays here due to the procedure or due to COVID.
Well, I'm in agreement with you that, in hindsight, I was supportive of the rulemaking change in June. But my interpretation, and I blame this a little bit on COVID, I wasn't able to sit down with the department of the intent of the rule. I thought the wildlife biologists were going to be hired to do the review to save Fish and Game on those that had a hit on that National Heritage Bureau report. But the decision was made by DES that all the permits were going to go to Fish and Game. And that to me is the major change. You've tripled the workload and you've tripled what applicants have to do. So I look back in hindsight that if it wasn't COVID, we probably all would have been in the room discussing what was happening and we would all have the same interpretation. But I can tell you, looking back, if I know where we'd be today, I probably would have opposed those rules. Because I right now it's not showing that it had worked. I hope that answered your question.
Yeah, thank you. And thank you, Mr. Chairman.
Thank you. Gary, I'm just curious, all this is happening because there was a lawsuit. What was the genesis of the lawsuit if this was working so well?
Well, I think it was the interpretation. I would.
Who filed the lawsuit?
I would let the department or Ari Pollock or the lawyers answer that question. If I'm not really in tune with the lawsuit, all I recognized was we immediately after the lawsuit went into changing the procedures. Mm-hmm. We tried some temporary rules in January with the rulemaking committee, and we ended up with this final rule in June. But I think the specifics of the court case, I would probably prefer to defer that to the agencies that were involved with the lawsuit.
I do sit on the GELCAR, or the rule where we look at rules, and I think a few of us have done that. And we've seen some departments really backlogged on some of their rulemaking, so that can really slow the process down if they're not up to speed. So I agree, rulemaking is an issue, but so just in general, you're in strong support, so it can help with the intent of the original bill, correct?
Correct.
Senator Gaida.
Thank you, Mr. Chairman. Gary, did I understand you to say that all applications are now being routed through Fish and Game?
All alteration of terrain applications are going to Fish and Game, which that's the problem.
And that's regardless of whether or not there is an endangered or threatened species within the confines of the area proposed within that application. Is that correct?
That's correct.
And is there a member from DES available that can answer the questions to who made that decision and why?
Let me look on the list for you, Senator.
While you're looking for that, Gary, Senator, I just want to ask this question. Does Fish and Game, I mean, they're already strapped. I mean, they probably could use a few more Fish and Game wardens out there. I'm just curious, do they benefit from each of these applications, or is their budget, do they get a fee for this?
No, they do. They do not get a fee for doing this review.
Right. So they have to use some of their resources to do these reviews rather than, maybe get another game officer or something like that. I know they're strapped. So.
But I think that was why the rulemaking required the applicant hire a wildlife biologist to do the review. So therefore, it would just be a paper check.
Right.
But the delay in these projects being delayed, I mean, I'm starting to hear it from contractors who plan on working on some of these projects in the spring, and they're concerned they won't be able to have the permit and get started in the spring. So I can already sense that there's a problem. But I think when it comes to the rulemaking, what DES did is try to, since all of them were going there, to try to make sure the applicants provided through a wildlife biologist the paperwork that was there. The issue is the procedures that Fish and Game should follow. It's a little gray after 6 months or more of having these rules in place of how this process is completely working.
We'll follow up on Senator Gaida's question.
Griffin, did you want to?
Thank you very much.
Thank you, Gary. We appreciate your testimony.
If I may, Mr. Chairman.
Follow up? Yeah.
Thank you. I really would like to inquire with DES, who made the decision to funnel all AOT applications through this process when it's not necessary. That to me is probably an administrative oversight, and I think it's something that could be corrected and likely solve most of the problems we have.
Senator, if I might, I do know that there's staff from DES and Fish and Game who are here, but I'm going to defer to Senator Avard. I didn't know if you wanted to hear more testimony from others before we bring in the departments, or if you'd like to hear from the departments now.
I can wait. That's fine.
Yeah, well, let's wait, and we'll let them hit follow up.
And just and no disrespect, but just as a time check to everybody, we spent an hour and 15 minutes on this one hearing so far. We still have 2 more bill hearings with quite a few people signed up to testify. So just to clarify that for everybody.
All right, thank you. And we'll hear from our next.
Okay. We have Kevin Nyhan. And Kevin, you are all set to speak.
Good morning. Can you hear me?
Yes. Welcome.
Thank you, Mr. Chairman, for the opportunity to speak today. My name is Kevin Nyhan. I manage the environmental office at the Department of Transportation. And very briefly, I'll explain some of the concerns that we have with the existing statute 212A93 and why we're in support of this bill. To answer Senator Gaida's question earlier, the alteration of terrain rule does require that a review of applications that result in the destruction or modification of habitat. So to the extent that there's an alteration of terrain permit that would impact the environment or potential or habitat for those species, those would be reviewed as I understand it, number one. Specifically to DOT, I don't believe that the existing statute goes far enough in recognizing that there are state agencies who do operate and do comply with the Endangered Species Act in all that we do, and that there are other rules under a separate chapter which do also refer to the requirements of 212A. As was mentioned before, that's the alteration of terrain rules, but also the wetlands rules, and that can be found at 30706B. So I guess there's an opportunity for clarification. I don't believe the statute goes far enough in finding that flexibility and the balance that Ari referred to before. When you consider that over the last 10 quarters or 2.5 years, the Department of Transportation has had 264 projects. Of those, over half, 144, already had to comply with the Endangered Species Act. So to the extent that we were already doing that work, the alteration of terrain rule referred to is essentially duplicative. The remaining 45% of those projects, or 120, are state-funded only projects, for which the department does have adopted internal policy that says we're going to also follow the Endangered Species Act for those. So essentially, de facto, all of our projects that we undertake are already complying with the Endangered Species Act, which is referred to in 212A and other sections of rule. So those are essentially our concerns, and that the statute doesn't go far enough. I also want to let you know that the department did work with Senator Bradley on an amendment to this bill, which I understand will be introduced, which is 260S. And based on my understanding of that amendment and what this bill is really trying to do, the Department of Transportation is in support. Thank you, and I'm happy to take any questions you have.
Does anybody have any questions? Okay. Thank you, Mr. Nyhan. We will bring in the next speaker. And that is Rick Vandepoel. I will bring Rick in. Okay, Rick, you're all set to testify?
Okay, thank you, Trish, and thank you, senators, for hearing my testimony today. My name, for the record, is Rick Vandepoel. I'm the principal at Ecosystem Management Consultants in Sandwich. I'm a wildlife biologist, and I do a lot of the reviews for these permits. I was also privy to the court case, was an expert witness in that case, and have been working with Department of Transportation, Environmental Services, Fish and Game in trying to resolve this issue. I have 6 points that I will summarize since I know we're short on time, but I think they're necessary to repeat in some cases. First, the term significant cannot really be easily defined, and I would recommend that that term significantly be struck from the language. Even Fish and Game is going to have a difficult time, and legislatively it can always be tested. So if we want to come back to court and get another ruling, put in a reasonable or unreasonable or significantly, a term like that, and I guarantee you'll end up back in court. I also am the chair of the Site Selection Committee for the Aquatic Resources Mitigation Fund, and as such have helped the process of providing mitigation offsets through the in-lieu fee program since 2010. It's been a very successful program, and I was actually in support of a mitigation option for this bill, and so I'm happy to see that included as a part of the bill, with one good solid caveat, and that is the fact that the ARM Fund, which oversees the in-lieu fee program on wetlands, is not the same as a mitigation program that would need to be designed for this statute, largely because habitats and species do not necessarily overlap. And I think that point was already made by Jim O'Brien. We have turtles and bats and migratory species that are on our list. And if you try and offset that by purchasing an acre of land someplace, or even 20 acres of land, that's not going to easily work. This leads me to my third point, and that is simply that Fish and Game is hugely underfunded, especially in this regard. I had served on the Senate Bill 48 with Senator Avard, the Fish and Game Study Commission. This was a singular conclusion we worked on for over a year, and without having any kind of permit offset in terms of a fee, I mean, $25 for a natural heritage check is peanuts compared to the project budget. And without funding Fish and Game to support another reviewer, we're going to slow the process down, even if we do have the mitigation offset as a part of this bill. So we really need to have a fiscal note attached to this. We really need to authorize the legislature, through the legislature, a fee that compensates for another reviewer or two at Fish and Game, not unlike the administrative fee, which is 20% of the ILF fund for the ARM Fund program. A 20% administrative fee that's produced tens of thousands of dollars to support a staff and a half person at DES Wetlands Bureau to run this thing. So consider that as my third point. The fourth point I wanted to make is simply that we have rules, as Jim O'Brien indicated, as probably the best alternative to trying to adjust this statute. The statute left in general in support of endangered species, I think is solid. I think the term jeopardize is significant, but as I made in my comments to the AOT hearings, both in January and June, we haven't defined the geographic area to which we're considering jeopardize.
Excuse me, Mr. Vanderpool?
Yes.
Yes, you are at 4 minutes, so if
Okay,
you could
thank
just
you for
finish up
that.
your testimony. Thank
I
you.
will finish up. We have a geographic area we need to define relative to jeopardize, and that too should be addressed in rule. So a lot of these issues, I think, can go to rule, and I would encourage you to, as Mr. O'Brien suggested, include language in the bill as an amendment that instructs the Fish and Game Department to craft rules to handle a lot of these issues. And again, I thank you for your time. Be happy to take any questions.
Thank you very much. Are there any questions from the committee? All right, so we agree that at least Fish and Game is a little underfunded, right?
Correct.
All right. I happen to be the chair of the committee, so anyway, I'm just giving you a little plug. All right. Thank you very much.
Okay, our next speaker is Cindy Balkus. Okay, Cindy, you're all set to speak?
You're muted, Cindy.
Yes.
There we go.
There you go. Yes.
I'll keep quick. I know time is short. Representing the New Hampshire Association of Natural Resource Scientists. And we do support, especially the first paragraph of this bill, as long as the word significantly accomplishes what the goal of this legislation is, and that is to relieve the problem and bottleneck that's resulted in the AOT permitting. The second paragraph of this we had concerns with, and we do understand the budget issues with New Hampshire Fish and Game, but we're not quite sure that this is the vehicle to do it with. And the other question we had is, although this is in the Endangered Species Conservation Act, it very clearly says unavoidable impacts to wildlife or habitat of wildlife. It doesn't specifically refer to threatened and endangered species. And so for us, there's a big difference between deer habitat and spotted turtle habitat. So those are a couple of our concerns with that portion. And we feel that much like the very popular and successful ARM Fund and In Lieu Fee Fund for the DES Wetlands Bureau, it can be accomplished, but I think we have to take care in this section. Thank you.
Questions from the committee?
Yep. Okay.
Seeing none, thank you.
We will bring in the next speaker. This is the last speaker signed up. So this is Suzanne Fournier. Bring Suzanne in. I don't see Suzanne on the list.
Oh, there she is.
Okay.
Unmute. Hello, good morning.
Good morning.
Hello.
Good morning. I'm Suzanne Fournier from Milford. I'm an environmental and wildlife protection activist. I first want to address one quick point. The Natural Heritage Bureau hits. They're not a complete record. So they miss the presence of threatened and endangered species on sites. That's why DES said to look at all the sites for an assessment. And then there are different levels of studies. First, the biologist looks to see if they are there. And then if they are there, then there's a more serious study that ensues. Just wanted to get that in. The lawsuit, a quick point on that, the justices said that it was a problem that DES and Fish and Game were minimizing harm, whereas the standard was to have no adverse impact. So they didn't like them minimizing harm, and that was an essential issue of that case, if you read the order. So for my testimony, this bill, as you heard testimony, was hastily done. It's quick, everybody's rushing. It was not well vetted with the wildlife protection community. It does not deserve your support. It really needs to be well thought out, the whole 212A. As you heard, it's a pro-development bill. It would cause serious harm to some of the most desperate wildlife species in New Hampshire by weakening the law that's intended to protect them. Weaken the law. It's not going to sit well with many citizens of New Hampshire. The bit of background about late 2019, the Supreme Court admonished both the Department of Environmental Services and Fish and Game for approving projects that cause harm to threatened and endangered wildlife. Okay, the Supreme Court was not against development. The justices recognized that projects could be designed for no adverse impact to endangered species. And they suggested that suitable studies of how the rare animals are using the property is very important to be able to design the projects to avoid negative impacts. What the Supreme Court said didn't sit well with DES, as you heard, and the contractors and developers. So for more than a year now, DES has been trying very hard to hold on to the status quo, to continue to allow impacts that they had been going on for decades. Now they want your help to weaken the underlying statute. They want you to legalize harm, and they'll call it minimize, but it's legalized harm. So the real danger in this bill is that these already imperiled species will be minimized out of existence, to use a phrase of a friend of mine. One site at a time, minimized out of existence. And that is the opposite of what the act itself, the Endangered Species Conservation Act, says, which is to help, if you look at the purpose of the whole act, to help the species maintain and enhance their population sizes, not shrink them. So the bill would actually allow developers to jeopardize the continued existence of the species if the jeopardy can somehow be labeled as insignificant. Well, it wouldn't be insignificant to the rare wildlife, would it? So I want to turn quickly to the finances of the bill. The proposed monetary mitigation program would allow rich developers to pay for the harm they would do to the endangered species, mostly by hurting the habitat. They would pay into a fund instead of being required to design their projects as they could do to do no harm to the species. One previous speaker mentioned losing some units of a complex. You can shrink a project size. You can change the timing of the project. There are different variables that can be changed in order to design it so there is no harm to the species. The money wouldn't even go to the endangered wildlife under RSA 212A. It would go to the Non-Game Species Management Act under 212B. And it could only be used for the Non-Game Species Management Program, because that law defines where that money goes. So the money wouldn't stay in 212A. It would go to 212B. And it would not go directly for endangered species mitigation, as some of the speakers pointed out already. So the bill also says that some of the money—
Excuse me, Ms. Fournier?
Yes.
Hi, I'm sorry, you're at 4 minutes. Could you just finish up your testimony? Thank you.
Yes, it's last point and then conclusion. So the bill says that some of the money could go to Chapter 206, which is the game species fund. Very interesting. So as I said, hastily done. So for all of these reasons and many more with no time to discuss, I hope you will oppose this poorly thought out, hastily done, and it's a dangerous bill. Once the wildlife protection movement people examine it closely and get back to you, it would weaken our precious endangered species law. So please say no. Thank you.
Thank you, Susan. Any questions from the committee? Seeing none, we appreciate your testimony. Thank you.
Well, thank
You are muted, Tricia.
Sorry, we do have some hands raised, and I believe we had a representative that wanted to speak. Maria Perez, Representative Perez. I don't see her on the list any longer.
Nobody from any other departments want to testify or follow up?
I do have 3 hands raised, and yes, Rennie Pelletier is from DES, I believe.
Let's get started there.
Okay. Mr. Pelletier, you can, or Renee, sorry.
Mr. Pelletier?
I can't,
Rennie?
we can't hear you.
You're muted if you are on. We see
How,
you.
can you hear me now?
There you
Yes,
are.
thank
Thank you.
Well, I'm French. Takes me a while to figure this out. So I think basically Senator Guida had some questions, and anyone else that may have some issues. I think Ms. Fournier kind of spoke to Senator Guida's question about why the rules came out after many public comment periods. And she was correct that the National Heritage Bureau identifies species that people have seen or run into and entered into the database. But as far as it being total coverage in the state, it does not do a justice. So the rules came about that to ensure that this property that perhaps wasn't in the Heritage Bureau's database was evaluated to make sure that in fact species were protected. That's how that came about. So I certainly am available to any other questions. I will say that the testimony you've heard that the process is quite simple. When an application comes in a DES, whom in fact accepts applications for the alteration of terrain program, generally in concert with that, a wildlife assessment will be submitted to Fish and Game. We will look at the engineering principles that are on the application vis-a-vis stormwater, et cetera. And Fish and Game has the staff academic knowledge to go ahead and evaluate a wildlife evaluation on a particular piece of property. Once we complete our review from the engineering side of the equation, we let Fish and Game know that we're ready to go as long as we hear back from them about the design and does it affect T and E species and protect them adequately. Once we get that nod, then we issue the permit. So we have been on a statutory time frame for 50 days for many years, based on all of the land resource programs are fee-based programs. So that is the real issue. I think it's been alluded to by many speakers. Staffing, Senator Divide, you had mentioned that perhaps staffing could be an issue. I think you heard Mrs. Fournier's testimony that this is an issue that we certainly are concerned about, making sure the T&E species are protected. We don't have our AOT program is professional engineers. We don't have wildlife biologists on staff at DES. 212 is a statute that is overseen by Fish and Game. So our goal here is we hope that whatever comes out of a statute change, if that happens, or a rulemaking process, that when we issue a permit, that there is due diligence has been done on the T&E species process to ensure that the permit gets issued justifiably protects T&E.
Senator Gaida? Oh, I'm sorry, Senator Waters. I saw somebody's hand up.
Yeah, thank you, Mr. Chairman, and thank you, Rennie. Do you think that there's any way to adjust the language here so that not every single one of these goes over to Fish and Game? I mean, I understand what you're saying about, well, just because somebody hasn't observed one or run over one, doesn't mean it may not be there, but I just didn't know if there'd be any way to sort so that not every single one had to go over.
Yeah, good. Thank you for the question, Senator. I think that the issue with T&E has been discussed earlier, is that the database does not have a real good coverage, if you will, in the state. So, you know, whether look at the evaluation of a particular site, depending on what degree of study is required, but I don't see that if we tweak the language in 212, that it would make a difference relative to making sure the due diligence was done on a development site of any magnitude, that T&E species were properly addressed and evaluated. So I guess my answer is no.
All right, thank you. Thank you, Mr. Chairman.
Rainey, but by adding this language, it does allow more of a process for rulemaking. Isn't that correct?
Yes, I would agree. And I think, as you well know, Senator, when we write rules or any agency write rules, their rules are tailored to what the statute is requiring. So if this bill were to pass, then it would go into a rulemaking process that in fact makes it very clear about how that statutory requirement would be adhered to.
All right. Any other questions? Thank you very much, Rainey. I appreciate it.
Thank you for the time.
Absolutely. And next.
Mr. Chair, we have two hands raised. And I just will, one hand raised, Miss Amy Charbonneau. And I would just remind that we have a time limit. Okay, Miss Charbonneau, you should be able to speak.
Thank you for the time. Thank you, Chairman and Senators. I'm going to be real quick. I'm from Continental Paving in Londonderry, New Hampshire. We employ approximately 350 people during the summer months, but what we try to keep as many people working, obviously when we can't pave in the winter. The time frame, I don't want to speak to the technical details of the bill. I more want to speak to the time frame and the 50-day that everybody's been talking about. So when we have a project we know is going to meet those requirements, we try and keep as many people working as possible. This specific winter, we have two projects stuck in the unknown time, and we end up laying off 20 to 80 extra people because you can't keep them working because you don't know when the project's going to start. So we have shovel-ready projects that are basically sitting on a desk somewhere, people that can be employed, jobs that can be done that we just don't, we can't do. We can't shuffle people around waiting for that 1 or 2 weeks to pass. You know, that's our biggest problem as far as the technicalities and all that go. It's just more the process and how we can manage people and keep people working. And that's our biggest problem with it.
So the idea of balance is again brought to the
right, exactly. And somebody had asked how it's affecting industry, so I just wanted to give so thank you for your time.
We appreciate that. Are you available for questions if any senators have any questions? Seeing none, thank you very much for your testimony.
Thank you.
And that is it for speakers for this hearing.
Okay, and so we will close the hearing on this bill, and we'll get started. Does anybody need a break, or we just go right into the next one?
Griffin's yes, we'll go right into the next one.
Yes, we go on break?
No.
I know, I'm kidding. You just give me a yes for both questions. So we'll start with SB 115.
Yes. Okay, and our first speaker.
Well, do we have a prime sponsor?
Yes, is the prime sponsor. Hold on, let me just pull. And that is Senator Prentice. Sorry about this. Just go down the list. There's a lot of people. Okay.
Senator Prentice available?
she was.
We have
Senator Prentice, are you, if you are listening, can you raise your hand?
If not, maybe Senator Waters could introduce the bill.
Thank you, Mr. Chairman. Tricia, is she here or not?
I don't see her, Senator Waters, at all.
If you don't mind.
Well, thank you, Mr. Chairman. For the record, Senator David Waters in Dover, and introducing Senate Bill 115, an act establishing greenhouse gas emission reduction goals for the state and establishing a climate action plan. And the bill has basically three parts. First, you'll see the findings here, which I think are important, not that they provide any new information or anything that we don't already know and has been demonstrated that's having impacts on New Hampshire right now. But I think what's helpful about the findings is you'll see that it identifies impacts that we know are having economic impact on our fisheries and on the coastline, our municipalities. They try to deal with these things, and in that context says, okay, it's pretty good. We're going to do offshore wind and try to limit emissions, and look what we can do to help out both our economy and the environment along the coast. The second part then gets to the heart of proposals, which are kind of familiar with us, aren't they? Because of what we heard on about Senate Bill was it 91 a few weeks ago on this matter, and that I think there really is a consensus that we need to look at how we're going to set these. There's national efforts underway, our bordering states, and New Hampshire's plan that we had kind of stalls out in 2025. So there's a reason here for setting those goals. And the third part of the bill, I think of no matter what anybody thinks about the other two parts, is really something that we're going to need going forward. That we get this inventory. There's some work done on this already, but that we get this inventory in a regular fashion, looking at, and very carefully, as you'll see put out there in Roman 4, Section 2, all the kinds of places to look. And so that we really would get the information we're going to need. Gas leaks, we talked a lot about that with pipelines a couple of years ago, residential development, carbon storage, new technologies, who knows, and then also impacts on forested lands and coastal marine and systems, and then think about, what kind of investments we can have there that are going to help our economy and help deal with some of these
Senator Waters,
some of these things. Yes.
I apologize for cutting in. Senator Prentice has shown up.
Yes.
I think she indicated that she really wanted to speak to her bill.
Of course she does. So I'm going to stop right now.
Senator Waters, thank you for stepping up to the plate. We appreciate it.
Yes.
Senator Waters, thank you. And Chairman Avard, members of the committee, I actually have been here. I don't know what the technical glitch was on my side, but I was madly raising my hand. So I'm sorry that I was missed in the crowd. So thank you.
Don't take too long correcting all my mistakes, please, Senator.
You did a great job. For the record, my name is Suzanne Prentice. I'm the state senator for District 5, and I join you this beautiful snowy morning to introduce Senate Bill 115. And again, thank you, Senator Waters. As we know, Senate Bill 115 is establishing greenhouse gas reduction goals, authorizing the Department of Environmental Services to inventory these greenhouse gas emissions on an annual basis and develop and report on a 5-year action plan, really what we would consider a new climate action plan. So briefly, Section 1 of this bill specifies under climate action plan the new reduction goals for greenhouse gas emissions using the 1990 standard, taking us to net zero by 2050. The last time that we had a full climate action plan worked on and published, and it was done very nicely, was in 2008, but we can see that a period of time has elapsed since then, and this document most definitely needs to be updated to reflect the state of our climate and climate change today. So let's talk about what else this bill does. It engages state agencies who work in the reduction of greenhouse gases to incorporate these goals into their planning and their work. Starting in 2022 on an annual basis, greenhouse gas emissions would be inventoried and published by the commissioner and made public on on an annual basis. By July 1st, 2023, a 5-year action plan under DES would be enrolled. This would, again, it would update the climate action plan as is. It would involve public comment and wide stakeholder participation, again, to bring us up to where we need to be today. This bill also encourages public and private investment opportunities. It emphasizes these investment opportunities to be worked on in low and moderate income areas, as well as involving minority groups. And it encourages the collaboration in a very important area in green jobs, which is workforce development and apprenticeships. There's also a repeal and replace for the state energy policy under RSA 378.37, and it puts in the energy policy that this is to meet the needs of our citizens, that it maximizes cost-effective and efficient energy efficiency. Again, it refers to the greenhouse gas emission goals that we've already previously identified. But it also recognizes here that this has to be done, this planning and this work in due regard and appreciation for both long-term and short-term financial goals and the costs imposed on climate change in the state to citizens and their businesses. I'll leave you by saying that one of the reasons that this is most important to me and to the folks who I believe will be following me in testimony is that this is about, this is about the fight for the fight against climate change, that the health and safety and well-being of not just Granite Staters, but our nation and our world are being impacted every day. And at every time that we don't move forward on a project, on a piece of legislation, an initiative such as this, we're just putting off what really needs to be done to move forward. We are in this world and in this nation, in this Granite State, battling parallel pandemics at this time. And although the pandemic we're most familiar with is, and we talk about is COVID-19, but climate change actually is a pandemic as well and came before that. So I appreciate your time and I'm happy to answer any questions that you may have. And I know I have some excellent and some experts behind me that might be better suited to answer some of your questions, but I'll give it my best. Thank you. And I'm sorry about the initial mix-up.
No problem.
Oh, thank you. We had 2 senators for 1. Good. Thank you for your testimony. Any Senator Waters for a question?
Yeah, thank you, Mr. Chairman, and thank you, Senator. I just think this is a really significant bill in the way that it combines an eye on economic development with the, trying to dealing with something that can hurt us economically in terms of emissions. And so, one question I wanted to ask about is that you mentioned in the first part of the bill, the effects of ocean acidification, and that's something that would be looked at in the report as well. And, just as a little preface to it, we established our Coastal Marine and Natural Resources and Environment Commission a few years ago. One of the first things we looked at was ocean acidification and the impacts it's having on shellfish and potentially on lobster. We've already lost shrimp. But just to mention that this morning, Massachusetts, which modeled a new commission on what we were doing in New Hampshire, came out with its report on acidification, which suggests that the loss here could be hundreds of millions of dollars, and particularly the potential loss of lobster. And isn't it the case that in something like that, a lot of it has to do with not emissions that are coming from around the globe, but that are right here in New Hampshire, that the nitrogen deposition is from our own emissions, whether from heating sources or from vehicles, so that it's something that if we do something, isn't it the case that this bill would say we can do something about these kind of impacts to protect our economy?
Senator Waters, there may be others who are better to speak to this, but what I will say is that this does, I think you are correct, this does take into effect or into consideration and moves forward, not just the global, but the New Hampshire unchecked problems in terms of, even, nitrogen disposition and other greenhouse gases that are, because we're not working with the comprehensive plan that's really been implemented and set these goals, we have these types of New Hampshire impacts. And I want you to know, you made me hungry talking about shrimp and lobster. So I'll stop there, and because I think that I believe Representative Oxenham is in the room, and she is probably better suited to speak to this, as well as I'd like to praise her work and Representative Weston's on really writing this bill. So we have to deal with our New Hampshire impacts and be part of the larger plan in our country and our world. Thank you, Senator Waters.
Thank you, Senator. Thank you, Mr. Chairman.
Thank you. Any other questions from the committee? Seeing none. Oh,
Senator Gaeta.
Senator Gaeta.
Yeah, thank you, Mr. Chairman. Thank you, Senator, for taking my question. Could you explain in detail exactly what the economic considerations to be reviewed in this bill would be?
So if I may, Senator Gaeta, I am going to hold and see if Representative Oxenham can provide that level of detail.
Okay, thank you.
And if not, I'd be happy to get back. I would be happy to follow up with you.
Sure.
And seeing no further questions, thank you very much, Senator.
Okay.
Thank you.
So, Mr. Chair, do you want me to bring in Representative
Yes,
Oxenham?
please, if
Mhm.
he is available.
You are all set?
Do you hear me?
Yes.
Terrific. Thank you so very much. Thank you, Chair Avard, and thank you to the committee for hearing my testimony in support of SB 115. I want to focus on the costs, particularly the costs of inaction and delay in addressing the current climate crisis. The American Society of Civil Engineers has calculated for every $1 we spend on road maintenance, that helps us avoid between $4 and $10 on repairs. So that's a 4 to a 10 times factor. Necessary investments in climate planning, preparedness, and action will be dwarfed by the cost of inaction. Continued inaction will produce massive costs associated with living on a planet with an unstable climate system. You can break down the costs into 3 categories: the direct costs, the indirect costs, and the costs associated with uncertainty. Direct costs are physical losses from more frequent extreme weather events, wildfires, and rising sea level. Indirect costs are associated with weaker growth and lower asset values. And the cost of uncertainty, this is from risk and volatility. And we all know that our businesses and commercial enterprises are loath to take action when they're faced with uncertainty. Between 2008 and 2018, extreme weather disasters nationwide cost us close to $1 trillion and roughly $100 billion a year. According to the National Oceanic and Atmospheric Administration, in 2017 alone, $318 billion was spent on climate and weather-related disasters. If we single out just Hurricane Harvey, it cost $100 billion in property damage. That's one storm, 1 year. The climate crisis is increasing the frequency of these extreme weather events because warmer air and warmer water contain more energy and therefore carry more destructive potential. Over the most recent 5-year period for which we have data, major natural disasters have more than doubled to more than 12 events annually. And of course, we all remember last year when we ran out of letters of the alphabet and had to go to the Greek alphabet. As to indirect costs, these far outweigh the direct ones. They lower economic growth, deplete savings, and lower returns on assets. The chair of the International Association of Insurance Supervisors put it this way, quote, "It's not so much the question of which asset classes are exposed, but rather, are there any assets which wouldn't be?" Hurricanes, floods, tornadoes, droughts, fires destroy assets that took communities years to build. Efforts to rebuild them then divert resources away from new productive investments that would have otherwise supported future economic growth. Now, we don't have the kinds of data on New Hampshire that we have nationally, because New Hampshire doesn't spend money on the necessary studies. But we do know that the uncertainty injected by climate crisis is more pernicious, longer lasting, and will steadily increase as we move further and further into uncharted territory. So what we really need now are investments in planning, preparedness, and climate mitigation. These costs pale in comparison to the costs of the inaction that have been described already. And I'm choosing the word investments carefully, and I'm relying on this from the Rocky Mountain Institute. Investments are payments and capital expenditures that usually deliver positive financial returns. Not every investment does, but in general, that's the concept. When we put money into an investment, we are expecting a positive payback. Let's just for one moment look at the grid. The Electric Power Research Institute estimates that upgrading our grid to enable and manage high renewable penetration is going to cost roughly $500 billion over the next 20 years. But it's going to deliver 2 trillion in tangible benefits, saving us energy, lowering costs, improving reliability. So again, $500 billion in costs, $2 trillion in payoffs. Excuse me. Other points here were covered already, so I'll just skip to my conclusion, which is that the rational economic decision for our state is clear. We need to plan, we need to prepare, and we need to invest in climate action today. Economic prudence and fiscal responsibility are clearly calling for us to start taking better care of our most foundational and all-encompassing infrastructure asset, and that is a stable climate. Thank you very much, and to the extent possible, I'll take your questions.
Thank you, Representative. Are there any questions from the committee? Senator Gaida. You're muted, Senator Gaida.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. Where in this bill is there any consideration of studying the economic impact on households, businesses, industries?
I'm looking at the bill. I certainly remember in our drafting that we discussed that at great length on, if I don't have the actual Senate bill in front of me, but under Roman numeral 4.3, it talks about providing an opportunity for small businesses, schools, housing associations, other community institutions to benefit in reducing statewide efforts. I believe also in section 2, I think also in the findings we talk about, yes, under C, New Hampshire manufacturing businesses, making sure that they're reaping the benefits by replacing fossil fuels with in-state businesses. Our energy businesses are all renewables, and we have a tremendous opportunity with offshore wind in the offing. Also here, at any rate, I think there's, it's not called out in a section, but it is repeated in various places. It certainly was the intent.
Follow up. Thank you, Mr. Chairman. I don't see any language in the bill that specifically incorporates economic studies of the impact on the business sectors that would be affected, and there are many. And I would ask if you and or the sponsors of the bill would consider a detailed economic impact study on all of the industries affected by the proposed changes.
I think that's a very positive idea, and I would certainly entertain such an amendment, and I would counsel Senator Prentice to do so as well.
Thank you.
Senator Quokka.
Yeah, thank you, Chair, and thank you, Representative Oxenham. Thanks for bringing this bill to us today. Would you say it's fair to say that there are provisions in here that would allow many of our businesses, specifically, utilities and other energy-related businesses, to make long-term plans for their business? I think now there's sort of a dearth of guidance out there. So is part of the function of this bill to enable them to engage in their long-term planning?
I do indeed. And just glancing further here, if I could roll back to the previous question where it talks about amending energy policy. It says, where did I just see that? To meet the energy needs of the citizens and businesses of the state at the lowest reasonable cost while providing for reliability and diversity of energy sources. And did that answer your question?
Yes, ma'am. I think it's just important to realize that there are many benefits to the legislation. Thank you.
Senator Waters, unless you have a follow-up. Okay. Senator Waters.
Thank you, Mr. Chairman. Just to note, I do agree with Senator Gaida on this. And I did want to ask, though, Representative, that if you look at the very last lines of the bill, it says the energy policy of this state shall be developed with due regard and appreciation for both the short and long-term financial and fiscal costs imposed by climate change on this state, its citizens and businesses. It shall also seek to mitigate the difficulties associated with the transition to a clean energy-based economy for the state's businesses, commercial entities, and labor force in a manner that does not impede the state from achieving the greenhouse gas emission reduction goals identified. And I think that, you know, here is where that issue comes up, isn't it? And that this would be the place that if we needed to assert some of the language, which I see kind of implied here, but make it much more explicit that we are looking at costs and benefits here. And wouldn't this be the place to do it, Representative?
Thank you very much for pointing that out. I was sure this language was in here somewhere, and that was exactly what I was trying to locate. I think it's more than implied. I think it's directly stated that this is the guiding policy. We want to make sure our businesses, our commercial interests, our residents are taken care of and protected as we go forward. That's our responsibility as legislators. Thank you so much for identifying that passage.
Thank you, and thank you, Mr. Chairman.
Okay.
Any further questions? Seeing none, thank you.
Thank you all.
Okay, members of the committee, we have 12 speakers signed up from the public. I'm going to go through them and we're going to enforce the 3-minute testimony limit. So if anybody is on and going to speak, I just wanted to restate that. And also, we are taking the people that have signed up first. Anybody that has their hand raised will be last. Okay, our first speaker is John Atherton. And Mr. Atherton, you can speak now.
Yes, hi. I'm John Atherton, and I'm speaking as a private citizen. I'm a retired academic, taught philosophy for 40 years. And it's mandatory for all philosophers especially, but all academics, to quote somebody somewhere along the line about something. So let me quote Winston Churchill, because he gives us a very apt comment here. He said, never let a good crisis go to waste. The climate crisis is an opportunity. And I think that we need to look at it that way. You cannot escape paying for the climate crisis. The only question is to pay a little now or exponentially more later on. If we think only in quarterly basis, then we're limiting our thinking to only a quarter of the opportunities. Without SB 115, the effect of ongoing climate neglect or death by future studies is to merely kick the can down the road into the lives of our children, thus damaging their health, their property and property values, and their job prospects. If we, on the other hand, see SB 115 as an opportunity, we can improve health immediately. We can stabilize and then increase property values. and we build a homegrown job force. That's well under 3 minutes. Thank you very much.
Well done.
Good job.
Any questions from the committee? Seeing none, thank you very much for your testimony.
Okay, our next speaker is David Bates.
The Honorable David Bates.
Oh, I'm sorry if, yes, I do not see him on the list anymore. Mr. Bates, if you are on, could you raise your hand? Okay, maybe we will come back to him. The next speaker is Mr. Below, Clifton.
Clifton, are you there?
Everybody left? Okay, we'll go next down on the list is Catherine Corkery.
We're batting at a 0 here.
Yeah, okay. Did I scare everybody with the time limit? Okay, let's see.
Oh, the mailman's coming. My dog's barking. I'm going to.
Trisha,
Yes,
New Hampshire Sierra Club, that would be Catherine Corkery. She's got her hand up.
thank you. Okay, go ahead.
Thank you. Thank you so much for taking my testimony. I'm sorry I don't know how my name appears on here, so my apologies. My name is Catherine Corkery. Thank you for taking my testimony today. I am the chapter director for New Hampshire Sierra Club. We have about 20,000 members and supporters in the state. And for the record, we support SB 115. And I will be brief with my testimony as I have submitted written testimony. But so to summarize, we support this bill because this is a shift from doing a 10-year planning document to an action plan. Everybody likes action plans. And we really think that is an important shift because we are a state with towns and cities across the state who are searching for methods to address climate, to become more energy efficient and energy dependent, and to address the climate crisis that is outside our doors. The climate crisis is here. It's routinely flooding the roadways and buildings along Hampton Beach. We have the moose, an icon of the state, and it is disappearing from our forests because the ticks are living longer with the warmer temperatures. And energy use and the climate crisis are forever linked because it is the greenhouse gases from our energy use that are causing the climate crisis. Scientists have told us that over and over again. And this is a bill that helps us recognize the enormity of this issue here in the state. And it provides leadership. With the leadership of the state, it could help us organize our thoughts and organize our practices and organize our norms. And one thing that this bill does that others have not is that it identifies and lifts up the historically disproportionately disadvantaged people, including the rural, the low-income communities, and people of color, Latinx, Indigenous, and the Black community members in our state. So that is why New Hampshire Sierra Club supports SB 115. And in our testimony, I supplied a report from last year from the Center of American Progress.
Excuse me, Ms. Corkery, that's 3 minutes, so if you could finish up.
Yes. I've supplied a report that summarizes what other states have been doing, and thank you very much.
Any questions? No? Okay. Our next speaker is David Creer. Mr. Creer, you're all set?
Yes, thank you very much for having me. I'll definitely be within my time limit here. So our opposition to this bill is pretty straightforward. We just think that a thorough cost-benefit analysis on the economic impact of any energy policy should be completed before implementing that energy policy. And in my rush to stay under the time limit, I forgot to introduce myself. I am David Creer, Director of Public Policy at BIA. Apologies for that. But yeah, that's my testimony. And if there's any questions, happy to take them.
Senator Waters.
Yeah, thank you, Mr. Chairman, and thanks for your brief testimony. But just had one question. So am I to understand from what you're saying that if we put language in there about a cost study, that you would support the bill?
Well, that cost, excuse me, that cost study would have to, in some way, be completed before the implementation of the energy policy. So, in this case, the bill sets standards already. So, doing a cost-benefit analysis would say, okay, this is how much what we've already done is going to cost you or benefit you, depending on how that study comes out. We'd really like to see that completed so that we can make a more educated strategy before we implement that strategy.
So if I may just follow up.
Yep.
So I guess in understanding your elaboration there, that let's say that we had the cost study and the goals were not implemented until after that cost study was done, then the BIA would support the bill.
Yeah, probably. You know, obviously, we'd have to see the language before we can make an official remark. But yeah, if we did a cost-benefit analysis and everything, you know, showed out that it was, you know, well done and, sorry, I'm blanking here, but, you know, that it would benefit economically to do it this way, then yes, we would support that.
Well, thank you. And I think it's really good to have on the record the BIA will support renewable energy goals if it sees there's an economic benefit to it. And that's good to have on the record. And thank you. And thank you, Mr. Chairman.
Thank you, Senator Waters. Any further questions? And seeing none. Thank you very much for your testimony.
Thank you. Great. Our next speaker is Mr. John Gage. Mr. Gage, you should be able to unmute yourself. There you go.
Yes. Hello, Chairman and members of the committee. Thank you for hearing my testimony. I'm John Gage of Windham, and I'm speaking as a New Hampshire citizen. I'm in favor of SB 115. I'm also the state coordinator of Citizens Climate Lobby, a national nonpartisan grassroots group working to create the political will to enable Congress to pass effective and equitable climate pollution mitigation legislation that has a global reach. Others have discussed the impacts on New Hampshire citizens and natural resources from carbon pollution. And there's lots of scientific reports done from the University of New Hampshire and elsewhere identifying significant costs related to local damages from climate pollution, both local and global. I want to focus on a different aspect of this issue, though. The Paris Climate Accord target of 1.5 degrees warming indicates also an emissions reduction pathway that identifies net zero emissions globally by 2050. The IPCC also identifies a carbon price that would help us get there, which is $100 per ton of CO2 by 2030 and rising afterwards, basically about $100 more each decade. So the way that I look at this from a New Hampshire perspective, from a business perspective, from a keep taxes low perspective, to keeping New Hampshire competitive in the US and global economy perspective, once there's a price on carbon, those states and countries that have lower carbon footprints will be more economically competitive. And so This is not something you can do all at once, because it involves replacing equipment like gas burners for heating and other energy infrastructure that has lifetimes of 20 or 30 years. In order to be the most competitive in a world with a high carbon price, our state should be acting now, reducing our carbon footprint where it's economically sensible to do so. So we will benefit from health and environmental changes by getting on a different emissions pathway globally, not so much locally. Although, as it was indicated, there are local benefits to reducing fossil fuel pollution. A lot of health benefits are related to reducing carbon emissions. But from an economic perspective, I would hope that the BIA would consider what the US Chamber of Commerce is recommending. They're saying we need a market-based solution, and it's going to take federal legislation to do it. The Commodity Futures Trading Association also recommends carbon pricing. The New England—
Excuse me, Mr. Gage,
Yes.
that's 3 minutes if you could finish up. Thank you.
I'll wrap it up. Okay. I could talk for hours about why we should do this, but thank you so much for looking at this bill, and I appreciate your time.
You got a minute to wrap up.
Terrific. Okay. So if you want to see some of the groups that have recommended carbon pricing, you can go to carbon-cash-back. It explains cashback carbon pricing, which is the bipartisan bill in Congress that has 87 co-sponsors, including Annie Kuster. This will put a steadily rising price on fossil fuel production and emission and imports. It rebates all the money back to households to protect family purchasing power and the economy, and it uses border adjustments to push our carbon price around the world. Canada has already implemented carbon fee and dividend. They will be reaching $130 per ton by 2030. The EU has carbon pricing. They're going to implement border carbon adjustments to charge us for our pollution and any other country that isn't charging for their own climate pollution when we import it across their border. And they're talking to Canada about extending that border adjustment. So carbon pricing is coming, and our state really ought to get on the right foot, reduce our carbon emissions ahead of time so that we are one of the more competitive areas in producing everything that we produce. Thank you.
Thank you very much for your testimony. We really appreciate it. Okay, who do we have next? Oh, I'm sorry, the questions. I apologize. Questions? Seeing none. Thank you very much.
Okay, next we have Susan Richmond. Is Susan Richmond on the call? Okay, we'll go to the next speaker. We have Cynthia Walter. Ms. Walter, you may testify now.
Hi, takes a second to get that unmute button. Yes, thank you. I'm a scientist. Can you hear me?
Yes, we can.
I'm a scientist. I see clear evidence that the current policies we have in New Hampshire regarding climate are currently hurting our job potentials, hurting our property values, and hurting people. For example, people with asthma attacks because of air pollution, people suffering premature deaths. There's solid evidence for those harms. And I hope if there is a cost-benefit analysis, those harms that I just described are tallied in those current costs. The costs of those inactions that we have right now are substantial. But going forward, SB 115 will help gain jobs. And I'd really like to pay a lot of attention to the section in the third part that addresses the idea of apprenticeships, and also the other section that's associated with rural and low-income people. Maybe not in this bill, but in another bill, I highly recommend that you push forward paid apprenticeships, you emphasize that, and recruitment of underemployed rural and low-income people, because that will help fuel the extra jobs we will need to do all this climate amendment. So we can gain the jobs from SB 111. We can also stabilize our property values. And we want to include the property values associated with inland places that are at risk for losing drinking water quality. So the cost of water is not just right along the seacoast immediately, but our drinking water is losing its quality because of drought and because of seawater intrusions. And those are going to limit our development business opportunities. So again, SB 115 doesn't fix all of that at once, but it helps slow the problem so that we buy time. We literally spend money to buy time, which we need to fix those problems. And finally, it will help protect people. Every gas and oil burner that you take out of your house releases fewer emissions that your neighbors are breathing, and those kids can now play outside. You have fewer medical bills and so forth. So I encourage you to keep going with this bill, make it as strong as you can, and address the business side by simply saying that SB 115 tells our neighbor states and other investors around the country, New Hampshire is open for business in the new energy economy. We're not behind the times. Thank you.
Questions from Ms. Walters? Seeing none.
Okay.
Thank you very much.
All right. Our next speaker is Mike Fitzgerald from the New Hampshire DES.
Welcome, Micah.
Oh, sorry. I pulled in the wrong person. Sorry.
There we go.
Okay, there we go, Michael. You should be able to speak now.
Good morning, Mr. Chairman. Can you hear me?
Yes.
Yes, and if I could also ask that Christopher Skoglund of the of DES also be elevated to participate and unmuted. Chris is
Sure.
Staff person that works on climate issues primarily.
Okay, hang on one second. Oh, there we go. Thank you.
So good morning, Mr. Chairman, members of the committee. Thank you for the opportunity to provide some information to you. My name is Michael Fitzgerald. I'm the Assistant Director of the Air Division of the Department of Environmental Services. Our division conducts most of the work relative to mitigation and planning for climate change that's being done by the department, and I'm here representing the department. I also have with me Christopher Skoglund, whom I mentioned previously. I would like to state up front, DES takes no particular position on this bill. By way of context, we did see language very similar to this last session in the House. That bill died, I do think, during the COVID crisis in last year's session. But I would note that that bill had an FN, and there is a similar bill in the House this year, HB 172, that also had an FN, also has an FN. And I'm not sure why this bill did not, we did not get a fiscal note request on this bill. But that's the thrust of my comments, that although we certainly understand the need for the activities and the actions outlined here and concur with a lot of what is stated in the bill in terms of impacts. We currently receive no funding from the state, either general funds or other dedicated funds, to support climate planning activities. As I said, I do have one staff person, and that person is funded through a combination of EPA funds and a large environmental settlement, a national environmental settlement that New Hampshire benefited from several years ago. However, the EPA funds have been level funded for a period of more than 10 years. And those funds, that actually is a cut because level funding doesn't account for increases in costs. And so that fund, which provided funding for approximately 20 positions back in 2012. Today funds 12 or less positions. And the AEP funding, the environmental settlement funding, I only have 2 to 3 more years of funding for that one staff person. So I would just like to note that this bill puts a very significant burden on DES. We provided a letter of testimony that outlines that we would potentially need at least 3 staff people. And by way of context, I'll go back and then refer to the 2009 climate plan that we produced. Again, at times that plan required upwards of 10 DES staff people, not all at the same time, but 10 various staff people, 2 or 3 that were primarily dedicated to that from that EPA funding that I mentioned that now only funds 12 people as opposed to the 20 that it funded back at that time. And that the 2009 climate plan also was guided by the work of a 29-member bipartisan commission that was appointed by the governor, but represented business, academia, the industry and environmental interests, as well as government and legislative. So, and it included the input from more than 125 people in 6 work groups. So, as you can see, that plan was although it could serve as a baseline, as a foundation for work being done here, and that plan did conclude that there were significant environmental benefits. We do also in our letter note that we would potentially need a consultant to determine some of the economic benefits and costs and benefits that Senator Gaida was interested in hearing about. And that we would probably need at least 3 additional staff members to complete the work that we have put before us in this legislation. And therefore, we, again, there is no FN on this legislation, but we thought that that's information that would certainly be needed. The department does not have the current resources that we had back in 2009 to carry out the activities that are noted here. So with that, I'll conclude my testimony. I indicated to your assistant, Mr. Roberts, that I would be available to answer any questions that the committee might have with regards to the legislation as well. I'd be happy to do that now or later as you care, Mr. Chairman.
Thank you, Michael. I'm curious, any questions from the committee? Senator Gaida. Senator Waters. I'm looking at you while you're raising your hand.
Thank you, Mr. Chairman. Look, I know we both have a substantial dome, but I get it. Thank you for your testimony. And I just think that, I just want to take a moment to note how extraordinary it is that we have this lack of resources going into the climate crisis in our state agencies. And so my question, and it's just something we've wrestled with and tried to get into the budget for several years, as you well know, and it becomes tough. But my question on this would be that would you say that it is highly likely that the demands on DES to deal with the climate crisis will only increase in subsequent years?
Well, again, the demands on DES come from the legislature, and so it depends on what we're tasked with. I would certainly concur that the need for action and for planning and so on will only become stronger. But whether or not we are actually tasked with, we take our direction from statute, and so what what we're directed to do in statute, we will certainly attempt to do. But I would not disagree that the need would become more exacerbated in the future.
Well, and thank you. And Mr. Chairman, I guess that we should introduce a bill then that will say that the climate will stop changing, and then the legislature will take care of it, right?
As it ever.
Thank you very much.
That would be very helpful.
Yeah. I have a question. Is this bill pretty much identical to the House Bill 172 FN?
I am looking at that right now, but I do believe that it is extraordinarily similar. Mr. Skoglund has looked at both of them. I think they're the exact same language, and I think that they're similar to the bill that was introduced last year.
And the FN basically adds funding?
Well,
Mike, if I'm-
excuse me, the FN identifies the need for funding. It doesn't, adding any funding would be up to your committee or the House committee to consider what types of resources they might want to attach to the bill if they so deemed.
What is the fiscal note on that?
I'm sorry?
What is the fiscal
Mike?
note? Chris?
Yeah, I'm sorry if I could step on my boss's toes. I am not certain that we actually have a fiscal note on House Bill 172. We did have the fiscal note on House Bill 1664, which was introduced by Representative Thompson last year. And that is where some of the analysis that Mike just provided was drawn from.
Chris, we'll have to go back and check, but I believe 172 is an FN bill.
Okay.
I believe I looked at it yesterday and I saw FN in the title.
Michel Roberge, could you check that for us?
So I mean, I'm sorry, Matt, Mike, I'm gonna have to side with Chris. I'm not seeing. I don't see an FN on House Bill 172. However, the bill that you referenced from last year, House Bill 1664, did have an FN, and if the committee would so desire, I can share a copy of that bill and the fiscal note with the committee in the OneDrive.
I stand corrected. Thank you.
Thank you very much. Any further questions? Wow, we're doing really well today.
Yeah, okay. Okay, so our next speaker is Doug Marino. Mr. Marino, you should be able to speak now.
Hi, can you all hear me?
Yes.
Hi, thank you so much, Mr. Chairman, and honorable members of the committee. Griffin and Tricia, it's great to see you again.
Well, good to you.
And yeah, so my name is Doug Marino. I'll make my testimony very brief. I work for an advocacy organization called 603 Forward, and our goal is to advocate on behalf of New Hampshire youth and try and make New Hampshire a better and more equitable place for young people to live. And so I want to thank Senator Prentice for bringing this critically important bill forward. Climate change is an existential threat facing the youth of New Hampshire. Communities in our state, particularly on the seacoast, are very much at risk as sea levels continue to rise. In order to make New Hampshire a viable place for young people to live, we have to take immediate action to combat climate change. The goals laid out in Senate Bill 115 represent substantial steps in the right direction. And it's not only the morally correct thing to do, but it's an economic necessity. So I applaud the Senate for hearing this bill, and I strongly urge you to support its passage. And Mr. Chairman, I'm very grateful for the opportunity to speak today. Thank you.
Thank you, Doug. Any questions for Mr. Marino?
No.
Seeing none, thank you.
Thank you. Okay, the last speaker I have is Leslie Anderson. Miss Anderson? Okay.
Good afternoon. Can you hear me?
Yes.
Hi, my name is Leslie Anderson. I represent the Propane Gas Association of New England. We're a regional trade association representing over 40 New Hampshire businesses with over 2,700 employees. I consider myself an environmentalist. I have a master's degree in environmental management. I'm an environmental attorney, and I worked for 2 years for the Maine Department of Environmental Protection as Director of Innovation and as a Bureau Director. I applaud the goal of the state of New Hampshire for its goals to reduce greenhouse gas emissions, and I believe that diversity of energy needs to be a key component of New Hampshire's energy strategy. Propane is an EPA alternative energy. Using propane accelerates decarbonization. It takes 2.5 times the amount of source energy for electricity from the grid to reach your house than for propane. And this is why propane is the preferred partner for net zero housing. And there's no cleaner way to heat hot water than on-demand propane water heating. It has fewer emissions than any other source in a life cycle analysis. Using propane furthers the fundamental environmental goal to reduce, reuse, and recycle as promoted by both EPA and the Department of Environmental Services. Most people do not realize, but propane is a beneficial byproduct. About 5% of it is generated during natural gas processing. And if you don't capture propane and beneficially use it to offset another energy source, it is wasted energy. We believe that it should be a key component of the New Hampshire energy strategy, since reusing this underutilized byproduct is essentially carbon neutral. Today, worldwide, there is more propane produced than is used. So the more we can use it to offset other energy sources, the better it will be for our environment. We do disagree with the section 3 where they talk about zero emission energy sources, because this is a misnomer. Carbon impacts occur from all energy sources, whether it's from a coal generated power plant that's used to construct steel for wind turbine blades in China, or if it's from the electricity that's generated from natural gas plants, which switch over to burning diesel fuel during extreme cold winter events here in New England. Electric batteries require heavy metals. Cobalt and lithium are not renewable. And New Hampshire's approach to climate should be holistic and look at a diverse energy plan that includes multiple low carbon energy sources to form its climate solution. We believe propane should be part of this solution. And I'd be happy to take any questions that you have.
Interesting. Any questions from the committee? Thank you very much for your testimony.
Okay, and we have one raise their hand, Sheila Vargas. And Ms. Vargas, you can unmute now.
Thank you very much, Trisha. I'm sorry, I have a noisy dog who's hunting squirrels right now, so I may have to mute myself and go handle that situation.
Oh, we love dogs.
Yeah.
Well, mine's up for adoption, so let me know.
Not that much.
Thank you very much, Chairman, members of the committee. For the record, my name is Sheila Vargas. I am here representing the Nature Conservancy in New Hampshire today. I believe you heard from my colleague Jim O'Brien earlier. I am going to just provide some brief remarks on behalf of both the Nature Conservancy and New Hampshire Audubon. Carol Foss from New Hampshire Audubon did submit our joint written testimony, so I won't elaborate too much on that, but I did just want to voice both of our organization's support for this legislation. And, you know, a couple of the reasons for that, I don't want to reiterate too much of what you've already heard, but New Hampshire continues to lag behind all of the neighboring New England states on making progress on curbing emissions. And all the goals stated in this legislation have already been accepted by our neighboring states and their science-based emission reduction goals. The other reason that we are supporting this legislation is, I'm sorry.
No, you're fine. Keep going.
The ability for this legislation to actually bolster the clean energy economy. I know you've heard a bit about that, and I really appreciated Representative Oxenham's comments around having emission reduction goals set in statute, providing a sense of stability for the clean energy economy and for renewable energy businesses to come to New Hampshire. And lastly, I would just like to say that we really appreciate the inclusion of lines 21 through 24 on page 3 regarding encouraging public and private investment towards rural, low income, low to moderate income and minority communities in New Hampshire, as well as the fact that that section specifically points to small businesses, schools, affordable housing associations, and the like. Our organizations are extremely committed to protecting our vulnerable and marginalized populations in New Hampshire, especially while mitigating the effects of climate change. So all in all, we do support this bill. We hope the committee will vote to pass it, and I'm happy to answer any questions.
Okay.
And of course, my dog stops barking now.
Any further questions? Seeing none. Thank you very much, Sheila.
Okay. All right, and that is all I have for this bill, Senator.
All right, so we'll
Ask
close.
a question, Mr. Chairman?
Certainly.
Thank you. I have to go to another meeting, a panel I'm on at 11:45, and I could probably keep one ear open if you want to exec, but I didn't know what your plan was.
I would like to exec at least 129 for today, and I don't know if that's something that you, if the committee's ready to do.
Well, if I just may say, although I mean, I don't want to speak out of order, but I think we have some suggestions for some amendments that I think we probably need to do that maybe we can't hash out in exec today, but whatever you choose to do, Mr. Chairman, and but I don't know if I'll be able to get back in, but thank you.
Okay, so you won't be here for the next bill.
Yeah, I have to leave at 11:45. I'll try to come back in, but thank
okay.
you.
And are we ready for the next bill or?
Yes, if you want to open the hearing.
Okay.
Yep.
And so we'll open up the hearing to SB 114 FN, and we'll hear from the prime sponsor.
It's Senator Whitley.
Thank you, Mr. Chair, and good afternoon, members of, well, almost good afternoon, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve New Hampshire Senate District 15, which includes the wonderful communities of Concord, Pennacook, Henniker, Hopkinton, and Warner.
Welcome.
I am proud to bring forth SB 114 today, otherwise known as the Inclusive Outdoors Act, to ensure that everyone who comes to New Hampshire to visit our open spaces and public lands feel welcome and, most importantly, safe. Because everyone should be free to enjoy our outdoor spaces without discrimination, harm, or threats of violence. The importance of New Hampshire's outdoors to our economy and cultural identity is immense and remains a large reason why people come to New Hampshire to live, work, and play. This has only been reinforced recently as Granite Staters took to the woods and other open spaces to cope with the ongoing pandemic. My own family spends countless hours and days enjoying all of the beauty and recreation that New Hampshire's outdoors have to offer. Recognizing the importance of New Hampshire's outdoors to our state, this bill serves as a public commitment that our open spaces and public lands are welcoming, inclusive, and most importantly, safe. This is more than just about the freedom to enjoy the outdoors without disruption. It's about the freedom to enjoy our beautiful open spaces and public lands safely and without fear of discrimination and violence. Earlier this month in my own district, white supremacist vandalism was found on local trails. The incident was publicized and rightly disavowed. But unfortunately, incidents like this happen all over the state, but go unreported due to fear, misunderstanding, and longstanding distrust. This bill fully aligns with the work of the Governor's LEACT Commission and takes that work outdoors. The bill requires public protocols and policies for how the respective departments that manage our public lands will deal with civil rights violations. It requires public and transparent reporting of all incidents and requires that all law enforcement undergo the training recommended by the LEACT Commission. As elected leaders, we have a responsibility to reverse the effects of racism on our access to outdoor spaces and support policies that have racial justice at the forefront. This bill is just a start. So the committee hopefully has an amendment that was sent a few hours ago, reflecting some conversations that I had and many stakeholders had with the Department of Natural and Cultural Resources, Fish and Game, and with Chief Skippa, with the director of the New Hampshire Police Standards and Training Council. So most notably, you'll see that Section 5 aligns the requirement for all New Hampshire law enforcement with the governor's recent executive order. Many stakeholders involved felt like it was important that this requirement for the training be in statute rather than just in the executive order, because statute is more permanent and more public facing, and reflects the will of the New Hampshire legislature. So I'm happy to take any questions on the bill or the amendment, and hopefully there's some folks behind me that can answer some more technical questions as well.
Thank you, Senator. Are there any questions from the committee? Senator Corker.
Yeah, Senator Whitley, I wondered if you could just briefly give an example of something that may have occurred here in our state that would give rise to the need for this bill.
Yeah, thank you for that question, Senator Perkins Quokka. So I did mention an incident that happened in my district on the Concord Audubon trails. I mean, they are private trails, but these type of incidents do happen all around the state. And we know that from stories that people have shared. In this instance, there was vandalism all across the trails with white supremacy stickers and other hateful speech. And the New Hampshire Audubon Society did an incredible job of recognizing and publicly disavowing this horrible vandalism and saying, no, this is an open space that is welcoming to everyone. So that is just a small example, but we know that this does happen all across the state. But as I mentioned, it often goes unreported because many folks, as we know, communities of color have, rightly so, have a historic distrust for folks in charge and particularly for law enforcement. So this bill will go a long way to rebuilding that trust by making a very public statement towards how inclusive and welcoming our outdoor spaces are. Thank you.
Any further questions from the Senate committee? Seeing none, thank you, Senator. Appreciate your testimony. And we have other people who want to testify.
Yes. Okay, we have Representative Wazir. Okay, let me bring her in. She is signed up, not on. Okay. Catherine Corkery. Ms. Corkery, you can speak. Thank you.
Excellent. Thank you. My name is Catherine Corkery. I'm from New Hampshire Sierra Club, and I am chiming in support of this bill. And I just wanted to share that at the heart of this bill is the Sierra Club motto. Our motto is to explore, enjoy, and protect the earth. And we all know the benefits of being outdoors are enormous, and they've been critical during the pandemic, as the senator spoke. But unfortunately, these outdoor spaces are not, that members of our community are not unable to enjoy and explore the outdoors as I do as a white person. And the problem is clear that racial discrimination and bigotry have hindered targeted community members from fully enjoying. And the state of New Hampshire affords all people the benefits of the outdoors without discrimination based on their color, their race, their ability, their gender identity, their national origin, their ethnicity, religion, their creed, their sexual orientation, their preferred language, their incomes or their sex. And it is very important for the state to address that problem for these folks. The threat of violence persists on our public lands, and it is difficult to enumerate because the violations are not routinely or systematically collected throughout the state. And that's what this bill is aimed to do. We have seen throughout this journey of this bill that complaints are not addressed uniformly or adequately. And or with the seriousness that they require. And it is clear that we need to have a clear practice or operational procedure to address the civil rights violations. And right now, there are no rules or policies in the Department of Natural and Cultural Resources or Fish and Game to address.
Ms. Corkery, you're at 3 minutes. Could you finish up your testimony, please? Thank you.
Thank you. I will. The bill is aimed at addressing and directing the departments to develop these policies and operations to address these violations. And we aligned with the law enforcement community, their efforts with the Lee Act. And with that, I ask you to support this bill with the amendment, and we'll take any questions and either here or offline. Thank you.
Are there any questions from the committee members?
Okay.
Seeing none, thank you very much.
We have Representative Maria Perez. Representative, you're all set to speak.
Thank you for giving me the opportunity. It's my honor and my pleasure to speak in front of you. I'm a State Representative Perez. I represent District 23 Milford. And I'm supporting this bill because as an immigrant, my family enjoyed the outdoors. And one of the things that I personally saw last year during the pandemic, we're still under the pandemic, but we enjoyed the outdoors. And we have one of the trails that I usually go and walk alone all the time. And then we had white supremacy stickers put on some of the signs on the trail. And to be honest, I don't feel safe anymore. I feel unsafe. I feel very unwelcome. I have medical conditions that I should be walking and I should be like exercising and doing things outdoors. But after this incident, I've been like not like really taking walks out on trails. Like I feel unsafe. And then I just supporting this bill and any amendment because as an immigrant, I just put myself in the shoes of others just because the skin color or the religions or whatever they look like, they've been discriminated. And then to be honest, myself personally, I was walking my dog in my neighborhood because I love walking. I do it for my own health. And I was approached by someone when I was walking in a small trail by my house, and I was told that my family and myself is not welcome in the neighborhood because we are Hispanic and immigrants. That was the hardest thing to do because I've been in this country for almost 33 years. And I do the best I can to help my community. And I always support my community and I do whatever I can. My husband and myself, we do whatever we can to support the community. If from someone told me that because we are immigrants and we didn't born here, we don't belong to the neighborhood, and then that person told me that my family needs to leave the neighborhood and we need to leave the town because we don't belong here. That was hard. So that's why I support this bill, because I think with all this stuff is happening right now in our communities, having the park recreational and the police officers and everyone taking this training is going to help us to unify our communities and then feel the welcoming for everyone in our communities. And I believe this is something that we need. And that's all I have to say. Thank you so much for the time and the opportunity to speak.
Thank you, Representative, for your testimony and for your service. And some people can just be morons, and that's extremely unacceptable. Just unacceptable. Is there any committee members have any questions? Seeing none, thank you.
Thank you. Okay, Senator Whitley is going to read Representative Wazir's testimony. Senator Whitley, you should be, okay.
Thank you, Mr. Chair. Representative Sophia Wazir, who's a co-sponsor of the bill, had to take her child to the doctor. And so she has asked me to read her testimony, if you're okay with that, Mr. Chair. Great, thank you. So this is from Representative Sophia Wazir, who represents Ward and Concord. I am here to support in favor of SB 114, an act relative to the enjoyment of publicly accessible and publicly funded recreation areas. New Hampshire's natural beauty, from the shores of the Merrimack River to the White Mountains, is part of what makes our state spectacular, along with the people who live here. In more typical times, more than 3 million people come to enjoy our state and the nature we residents enjoy year round. During these COVID times, nature has served as a refuge for many. My own family has explored nature around Concord and gone for nature walks. I would hate for my 8-year-old daughter to stumble on that kind of hateful white supremacist stickers and messages that were discovered at the Silk Farm Sanctuary of the New Hampshire Audubon last November. I would be terribly sad to see her beautiful curiosity and new reading skills put to use to learn about the kinds of hatred and discrimination toward one another that sadly exist in our world. This bill helps to ensure that public lands and publicly accessible spaces will be safe havens for all, and that those who wish to create an unwelcome atmosphere are quickly stopped. This bill includes training for those who work on our public lands to ensure they have the support and important skills to do their jobs well and to help keep our lands welcoming to all. Whether it is the same-sex couple camping in a state park, an African-American family going for a hike, or a family who practices any one of the many religions that make up the beautiful mosaic of our state, they all deserve to be treated fairly, equally, and made to feel welcome. For me, my parents and I have experienced hardship in our lives. However, it is my 3 children I think most about when I hear stories about hate speech, vandalism of this type, and discrimination. I do not want them to experience these things, and I know it would be very difficult to explain to them the hatefulness that inspired such actions. None of our children should experience that in some of the most beautiful places on the planet, here in the state of New Hampshire. Furthermore, our state relies on these millions of diverse tourists who also should feel welcome, not just in our businesses and hotels, but also when enjoying nature and out for a walk or hike. I hope you will support Senate Bill 114 to ensure that New Hampshire is welcoming to all people. Thank you.
Questions from the committee? Seeing none, thank you very much.
Thank you, Mr. Chair.
Okay, next we have on our list Cynthia Walter. Cynthia, go ahead.
Yes, hello again. Thanks. You guys have tremendous fortitude, patience. You're still here. So this one addresses, I had hoped we might be hearing from folks who are actually the managers of public lands and also fish and game folks and so forth. But maybe I'll try, I won't be speaking exactly for them, but I've worked in collaboration with those folks for over 30 years, leading hundreds, literally hundreds of field trips with students from urban and suburban and rural communities to visit these public places as part of their science education. And what we see is that these very dedicated managers of public spaces have so much training associated with safety issues, proper use of physical facilities, and wildlife, fishing, hunting regulations, and so forth. But one thing that we don't have consistently in this state and many other states, I'm guessing, is the kind of training that's very, very new in the world, and that is associated with de-escalation and handling complicated interactions associated with discrimination. So this law sets everybody on a great step forward to give everyone the same kind of training associated with discrimination considerations that occur outdoors, and those are very complicated interactions to manage. I can only speak to some cases, but I won't get into details. But So this bill is needed not just before the occasional sign here or event there or something like that. This sets forward a statewide consistent planning to train everyone. The other thing it does is it sets forth the ability to keep good records. And this will show that these incidents are as rare as we hope they are, and that they're going to get even rarer. If we don't keep track of these things, then the public will be suspicious. And by public, I mean people who are coming from other states from 1 or 2, 4 hours away. That's a huge reservoir of wonderful visitors who also bring economic development to our state. We now make billions of dollars off of recreation, outdoor recreation in New Hampshire, but our neighboring state makes even more. Vermont makes even more money off of visitors. So if we are more inviting to more visitors, more people enjoy our wonderful environment, but we also get to make a little bit more money, which doesn't hurt anyone at all. Thank you for listening. Bye-bye.
Thank you for your testimony. Any questions? Seeing none, thank you very much.
Okay, we have 3 more speakers, and we do have a hard stop at 12:15. Another committee has to use the Zoom platform. So we will go to Jules Good. Okay. Let me, Jules, you should be able to speak. Go ahead.
Hello, can you hear me?
Yes.
Good morning, members of the committee. Thank you for giving me the opportunity to speak with you today. My name is Jules Good. I'm here as a private citizen, a member of the disability community, and an accessibility professional working in the state of New Hampshire. I am a huge fan of this bill. I think it's very important that we make our public spaces safe and accessible to all people. And while I understand that this bill arose, in large part due to a racial bias incident, I think it's also important that we use this as an opportunity to take a look at the ways that we can make our public spaces more accessible to more people. The vast majority of trails, parks, fields, and other public spaces that I have been to in the state are really lacking when it comes to physical accessibility for people who are wheelchair users, who have other mobility devices that they need, or who have vision loss or otherwise need information communicated to them in an alternative way. And so I would like to suggest that, as you're looking at enforcement and things that people are coming to you with as issues that they're encountering at these parks and at these spaces, that you take accessibility concerns just as seriously as you would take these other concerns that you're talking about. I understand that there's a different process and there's a different level of enforcement that goes into that. But I think about the students that I work with, the kids that I work with who are wheelchair users or who are unable to access kind of traditional park and play setups. And it makes me really sad to think that they're missing out on that opportunity to play as much as their abled peers are. And so I would urge you to consider thinking about accessibility when you're thinking about changing these rules around parks. And I would be happy to connect with you to discuss some resources for making these spaces more accessible so that more people in New Hampshire can enjoy them. Thank you.
Thank you for your testimony. Any questions from the committee? Seeing none?
Okay. Okay, we have Manny Esposito. Okay, Manny, you should be able to testify.
Hey, can you hear me?
Yes.
Welcome, Manny.
Hi, Representative Manny Esposito from Nashua. I apologize, I signed in late, so that's on me. But I just wanted to, I am one of the co-sponsors of the bill, wanted to share my my support for the bill and its amendment. I also did want to share that, you know, this came from a personal space. I went to a school that was an outdoor school, and I also, my fiance she's from Rhode Island, used to come up to New Hampshire and would, like, she's Colombian and Puerto Rican, she would go check out the Kangamangas and then would go to Hampton Beach. They had a different name for the Kangamangas. It was the Quebrada in Spanish, which is kind of like almost like a mountainous trail. So, and they always would she would talk about how beautiful it was when she was a kid and, you know, loved the experience. So for me, this is, you know, for a person, people of color, it's so important to get to enjoy these spaces in the outdoors and to make sure that they're inclusive, because they just, it's not always the most welcoming space, as you've heard through some of this testimony. And I think that we can, you know, I think as New Hampshire, we've already established some great best practices and training for our state police. And I think translating that into our fishing game would be great. And, you know, I appreciate y'all taking the time to hear out the rest of the testimony, but I really hope that y'all would support this bill to make these spaces inclusive, so that everyone here in New Hampshire gets to enjoy the outdoors. So thank y'all.
Thank you for your testimony and for your service. Are there any questions from the committee? Seeing none.
All right, we have one more speaker, Asma El-Houni. Okay, you can unmute yourself. There you go.
Thank you so much. Yeah, my name is Asma El-Houni, and I'm with Rights and Democracy, but I'm here talking as a citizen of New Hampshire today. I am a Muslim woman. I wear hijab. I'm also a person of color, and I am strongly in support of this bill. I also want to state that I know this bill won't end discrimination, but I think it does send a strong message that we're being intentional as a state to try to end discrimination, instead of being okay with some of the things that are happening to us. I live in the Upper Valley, and I have a friend of mine who is also a Muslim woman who wears hijab, who was doing nothing. She was walking with her children. She has one child in a stroller, and she was stopped and asked if she was lost, and also where she was going, by a police officer. Though I know this might not be a big deal to some people, it's just a question, but my friend was indeed shaken by this experience and shared this with a group of other Muslim women. We have an WhatsApp group going. So yeah, this making her feel like there's something wrong with her, or making her feel like she doesn't belong in the community. I told her to complain, and she said she'd rather not. She is an immigrant, and it is incredibly difficult for people to complain about their experiences because of the possibility of what could happen when people complain. I also have another friend who is an immigrant in the Upper Valley as well. They were with their friends, their partner, in a park in the Upper Valley. Police came up to this person as well, and they basically asked my friend where they were from. They are an immigrant. That question makes us feel unwelcome. It doesn't mean we're not proud of where we're from, but there's no reason to actually approach someone to ask where we're from. So again, it makes us feel like we don't belong. I love personally to exercise. I exercise actually every day. I do not go to my parks, and I do not go there because one, I look so different. I am a Muslim in hijab and I do stick out, but two, I worry for my safety. And just as Representative Maria and Representative Wazir shared their experiences, I've also had experiences where when I was out in public, like for example, walking to a bus stop, people would stick up their middle fingers. Or one day I was walking to a restaurant and it was just me and another older woman. And she basically said to me, oh, so now you guys are in Congress. You're trying to take over the government, right? Meaning Ilhan Omar is now in Congress. Anyway, long story short, I think this bill will help us feel more welcome and better help us feel safer to go to places where we might not otherwise go, kind of similarly to restaurants that have signs that say immigrants are welcome here. I definitely feel like it's safer for me to eat there than in places that don't have that sign. So I feel like this bill is kind of a way to let us know that, hey, this is an inclusive community and we do welcome everyone. So I support this bill. Thanks.
Thank you very much for your testimony. Are there any questions from the committee members?
Okay.
Seeing none, thank you very much.
you.
Is there anybody else to testify?
No, I was just going to mention Fish and Game is on. I didn't know if anybody had questions. Somebody mentioned that before. Do you want me to bring them in?
Not at this time, because we are now running out of time.
Yep.
So if there's nobody else here to speak, we will close the hearing.
Okay, yep,
All right.
you're all set.
I think we lost Senator Waters, right? Senator Waters.
Oh,
is-
he's
Well,
there.
I can come back if you're going to exec.
We have, is Senator Guida still here? I don't think Senator Guida is here.
Oh,
Oh, there he
yeah.
is. Okay. Is there a motion to exec?
I'll move to exec.
Is there a second?
Second.
Senator Waters seconds. Okay, and the roll call. Senator Waters,
Yes.
Senator Quokka,
Yes.
Senator Gray,
Yes.
Senator Guida,
Yes.
Senator Avard, yes. Okay. So I'm pretty much in favor of 129, and I don't know if there's a motion. If
I'll move OTP on 129, OTPA.
okay, is there a second?
I'll second.
Seconded by Senator Guida. Discussion.
Seconded by Senator Gray.
Senator Gray, I apologize. I called you Senator Guida. I know you're all looking the same today for some reason. My glasses. Sorry about that. I apologize. Senator Waters.
Yeah, thank you, Mr. Chairman. So, I don't know what the hurry is, but, if there is a hurry, I don't know what it is. But it does seem to me that we ought to add the rulemaking. And, look, the lawyers are going to sort out significantly, right? There are going to be lawsuits, and so it goes. But I thought what we heard was that the change that got made before is creating some problems. We ought to try to address that. But if we want to actually provide guidance and a way for DES and Fish and Game to figure out whether they really need to send everything there, and all this, let's have them make some rules. And otherwise, I just think we can pass whatever we want, but it'll be just, raw meat for lawyers, right? So why should we? I mean, we're here because of that lawsuit, right?
Right.
And so, what really is going to change unless we do it better? So I think that if we had a committee amendment that make rules, then I think we could stop quibbling about significantly and all that stuff and try to do it.
Senator Quokka?
Yeah, thank you. My comments are along the same line. I mean, I certainly understand there seems to be a few different issues this is trying to address. And as a decade-long housing advocate, I'm very familiar with AOTs and sort of how they affect the process. Understood that the bottleneck is an issue, but I mean, it sounded like we heard a couple of requests for amendment. I don't so far feel sure whether, we need to include the word significantly or not, or whether, as Senator Waters suggested, the rules could address it. And I guess overall, the worst solution would be if we create a lot of regulatory uncertainty and then the agencies are left without the guidance they need to make rules that really enable both sides to accomplish their goals. I mean, I don't think we want the development community to be waiting to understand their requirements. I don't think we want the conservation community to be concerned that what they were trying to accomplish isn't getting accomplished. So I know there weren't huge suggestions for changes to the language here, and so maybe we can accommodate those, at least the smaller ones, through amendment.
Okay. I do recall them saying that this gets the ball moving as far as rulemaking, and it starts the process. And so,
Mr. Chairman, if I may interrupt,
that was my understanding. That
they didn't. But the problem is, if we don't give them rulemaking under this, they can't do rulemaking.
How about a proposed change at significantly, as defined by Fish and Game and DES under 541A rulemaking, comma.
Yeah, I actually, Bob, why don't we put it at the end of that end of that sentence? Because then the, the other stuff gets, right after the bold. Because then I think it's not just significantly, it's other stuff too, that they ought to get some clarity on this for these developers, right? And
Well,
so I would just say.
it's 50 days is now up to 6 to 9 months.
Yeah, which is crazy. It's just crazy. It shouldn't be. I mean, that's how I referenced transportation. We just put on a hammer and said, if it's not done in 50 days, it goes forward. So I think if we put in what Senator Guida is mentioning at the end of the bold there, we're good to go.
Senator Gray, any comments?
The amendment would be fine with me.
Okay. Senator Quokka?
Yeah, that would be fine.
So
Is Jeb available by any chance? I can't. Could I have him pipe in just a little bit?
Yeah, hi, I'm back.
Okay, go ahead.
Thank
Jeb,
you.
what do you thought about that?
I missed that part of the discussion. I was on another call, so maybe Bob could explain it.
Yeah, on line 7, where we talk about do not significantly is a point of concern for a number of agencies and myself as well. Will make the lawyers rich. But if at the end we were to put in a statement or a sentence that says the term significantly, as referenced in this statute, shall be as defined by DES and Fish and Game under 541A.
I mean, that just pushes them to do what they would otherwise probably do anyway, which is a rulemaking process that everybody can participate in. I mean, it
Right,
would
but what it
seem
does is
like
it
that
says
would
that
be
the-
okay.
But it lets the legislature, lets us define who's going to decide what significantly is, not the courts.
Yes.
And if I may add, Mr. Chairman, though, and Jeb, I think that the question was that if we don't have the rulemaking in here, that it's not necessarily the case that their previous statutory authority for rules would cover this. And then I really think we ought to put it at the end of the bold there, not just significantly, but the other terms
Right.
there too, because we heard some comments about that. So if we put in what Senator Guida suggests, that the rulemaking will, I mean, I thought just at the end of that sentence, comma.
I would just put a period after
Yeah.
the word critical and then say significantly for purposes of this statute is as defined by the Fish and Game Department and the Department of Environmental Services
Yeah, but it's not just significant.
under 541A.
Yeah, but it's critical too. I mean, the word critical and, I mean, we had some discussion about that critical was not, each of those terms are not real clear. So I
Right.
just think that if it said, comma, as determined through rulemaking by those departments, we would.
The only problem with what you're suggesting, it would seem to me, Senator Waters, is that I think what's necessary right now, because of all the testimony that you heard, is that, everything has stopped basically, and it's now gone from a fairly easy process to one that's incredibly cumbersome. So if you write it the way that you're suggesting, I think you're saying the rulemaking would have to come first. I think it's important that it's sort of like there be a reset, that the statute changes, and this is where I think Bob's correct, if it's a separate sentence, you're probably better off in terms of trying to just expedite the backlog that's there now.
Okay, so I guess I just worry, Jeb, that we're just going to end up in court again. And, I think it'd be better if we let them talk about the other terms too well. But if you want to just focus on significantly in a way, that gets at the nub of the matter, doesn't it? So if we want to do a committee amendment along the lines that Senator Guida is suggesting, it's a way to go.
Griff, you clear on that?
So is this, I want to be sure that everybody's aware that Senator Bradley also had an amendment 0260S, which makes some changes to section 1. I'm assuming the language or the sentence that you guys want to add is within this amendment. It appears would take place after the period on line 12 of that amendment.
I don't have that in front of me.
Committee should have copies of this amendment in the OneDrive. If you do not or are unable to access, I can email it to everybody right now.
I did have it in my OneDrive, but every one of my PDFs says can't access.
That is terrific to know. Okay.
On all of them. That's why I'm kind of going back and forth.
So just send an email if you could. And
Yep. 1 second, everybody. Sorry.
That's all
and
right.
while that's happening, Mr. Chairman, do we want to, and Jeb, if you're still there, the question about where the funds would go, that just not sunk into that fund, but maybe directed towards the purposes of mitigation for these habitats or species. To be more specific on that, I don't know what people thought about that.
Again, I think that given the fact that this has become such a problem, I think it's appropriate for Fish and Game and DES to initiate rulemaking on Section 2 of the bill, and that would be a place for that kind of targeting of funding, as opposed to us trying to write something.
Okay.
I don't see that it's a bad idea, but I think it'd be, and generally that would be what rulemaking does, I would think, as opposed to.
That's what I was thinking, but.
So, but just to clarify that, so once those funds are put into the 2 funds proposed in statute, what you're saying is the rulemaking would clarify from those.
What they could be used for, and whether it would be targeted to the species in question.
Okay, so but
we would assume it would, but.
Understood, but we're sure that those funds don't have restrictions on them that would prevent them being used, for example, to purchase replacement habitat or something like that.
Getting far into the weeds on this, I think this right now just helps us get this thing going.
And the other thing I would add, and I didn't say this in my testimony, but Section 2 was written by the Attorney General's office, so it has been reviewed. It is general. And I think a rulemaking afterwards, would be appropriate to further define how the mitigation funds were used.
I agree with you. I'm just trying to make sure that we don't write into statute something that has an unintended consequence and ties Fish and Game's hands to then later use those funds.
Then probably the less we do, the better.
Right.
Okay. Feels like there's some unanswered questions here, but if you guys want to move forward, I can support the amendment Senator Waters put forward.
So we'll add the Bradley amendment.
So I have Senator Bradley's 0260S. What language am I putting where? And everybody should have it in their personal email box. Senator Gray, you're legislative.
At the end of line 10, bolded critical period, I would move that we add significantly for purposes of this statute.
Senator Gray, Senator Gray.
There is no bolded text in the amendment from Bradley.
Right.
That's right. My bad. I'm looking at the wrong one here. So
perhaps I think Bob.
Yeah, on line 12.
Yeah.
You'll see designated as critical.
Yep.
After that, critical period, significantly for purposes of this statute shall be defined by the Department of Fish and Game and the Department of Environmental Services through 541A rulemaking, or through rulemaking, whatever's appropriate.
Just reading it back, significantly for purposes of this statute shall be defined by the New Hampshire Fish and Game Department and New Hampshire Department of Environmental Services through RSA 541A.
Right.
So I'll
You put
move
significantly in
amendment.
quotes.
Yes, exactly.
Yeah, I'll move amendment 260 as with the changes proposed by Senator Gaida.
Second.
All right, roll call. Senator Gaida,
Yes.
Senator Gray,
Yes.
Senator Waters,
Yep.
Senator Quokka?
Yep.
And Senator Avard, yes. Okay, I think, are we running over somebody else's time?
Yeah, we gotta move.
All right, so is there a motion to move out of exec?
No, no,
move
we
it.
just-
You gotta,
you move the amendment. You have to move the bill now as amended.
I'll move the bill as amended.
Seconded by Senator Gray. All in favor, Senator Gaida,
Aye.
Senator Gray,
Aye.
Senator Waters,
Yep.
Senator Quokka,
Yep.
Senator Avard, yes.
Thank you, everybody.
And is
Consent?
there-
Out of executive session.
Well, okay. Did you want to move it to consent?
Yep.
Is there a second?
Second.
Senator Waters,
Yep.
Senator Quokka,
No.
okay, and Senator Avard, yes, but, okay. So Senator Gaida, would you want to take it out?
Sure.
Okay, so we'll have you take it out, and is there a motion to move out of exec?
Moved.
Senator Gray moves out of
Second.
exec. Senator Gaida seconds. Senator Gaida,
Yes.
Senator Gray,
Yes.
Senator Waters, you still there? Senator Quokka,
Yep.
Senator Avard, yes. And so
Move
that's
to
that.
adjourn.
Senator Gray moves to adjourn, seconded by Senator Gaida, actually in the reverse. Senator Gaida,
Aye.
Senator Gray,
Yes.
Senator Quokka,
Yes.
Senator Avard, yes. And I think we lost Senator Waters, so I would have exec more, but I think we're running on to somebody else's
I gotta
time.
go. Got a phone call.
okay.
So